Item 86 of the today's list. This matter was mentioned yesterday because the date was fixed on 12th June before the court below.
Yes, yes.
Your Lordship wanted to give this leave. But I give this leave. But let this matter be listed tomorrow at the top.
I think it will appear tomorrow.
Well,
I think it will appear tomorrow. I've given the date.
but
They can into calculator.
86.
With regard to upgraded matter, item number
ওটা দেখে নেবেন তো 11 তারিখে যেটা বলেছি ওইটাই
Item 86.
upgrade matter item number 181.
181. Yes.
Today is the date fixed before the learned court below, my lord. Learned court below did not granting any time to us, my lord.
For what?
For my lord, the hearing of the suit. My 7-2 application.
What is the impugned order?
Impugned was 7-2 application without hearing the 7-2 PD application was rejected.
Any caveat is there?
No caveat.
2 p.m. 181 2 p.m.
My lord, may I be permitted to mention one matter, my lord? Item number 63, my lord, yesterday we had mentioned, my lord has listed this matter, item number 63.
Yes.
My lord, tomorrow they will take the position. My lord, kindly take up this matter at 2 p.m, my lord.
Let me see how far I can proceed. Please.
My lord, I am waiting, my lord. Kindly take up the matter at 2 p.m. if it is not possible.
Yes, yes, Mr. Bose.
Two doctors, Millard, two doctors centering around Millard, the girl child. Millard, the matter. 6 June 2025, Millard order was passed. My learned esteemed friend's client has also questioned the 6 June because your lordship directed 4th June
Before
is
the learned trial judge. Yes.
Order has been passed, that has been impugned in their civil revision, which is item number 29. Yesterday, Millard, after serving the copy, I also filed the same application challenging the same order, which is yet to be listed on 12th. Since the leave was not granted, I did not pray for leave because in the evening, Millard, I got the number. So let it be heard together so that, Millard, there cannot be a conflicting order.
Item number 12.
Item number 29 filed by him.
29.
And mine is, Millard, 994.
You have been served with a copy in item number 29.
Yes, yes, he has served.
So it should appear at item number 29.
And Millard, may I have the liberty, Millard, to supply so that the file can be brought?
File ta dekho.
Yes, one section 24 matter is running in the monthly list. Last month also I have mentioned. Kindly direct to release the matter.
Section 24. Section 24 for want of determination.
Details this.
Due to extreme urgency, I want.
আচ্ছা ওটা একটা কাজ করুন tomorrow.
Due to urgency, my lord, one police help was allowed. Stay refused.
Wait till tomorrow.
That is the police. Already police was deposited, my lord.
Only mention those matters which cannot wait till tomorrow. Yes,
item number. My lord, one small indulgence. Yesterday, my lord may notice that I mentioned a matter for releasing the matter from your lordship's list. Item number 1066 of your lordship's monthly list. Because a recalling application is pending before my lord Justice Bhattacharya. This was supposed to come today under the heading to be mentioned, but it is not in the list.
ওটা দেখে নিন তো কেন
66 CO 215. Yes.
দেখে নিন
CO 2151 of 2024.
To be mentioned tomorrow.
Item number কিন্তু কালকে আমার লিস্ট গিয়ে দেওয়া আছে আমি
of your lordship's list, daily list, my lord.
Yes.
It was heard by your lordship on 25th of April, my lord. Thereafter, it was fixed on 25th of April 2020.
What is the item number?
147 of your lordship's daily list,
Yes.
my lord. Tomorrow is the date fixed before the learned court below, my lord.
For what?
My lord, for submission of the commissioner's report, my lord. In a suit for preemption, my lord, order 26 rule 9 was preferred and it was allowed. Challenging the same, my lord, I came before your lordship.
Today is the tomorrow is the date fixed for filing of the commissioner's report.
My lord.
Nothing will happen.
Lordship, may I have your lordship's kind leave to file a civil revisional application without the certified copy of the order. Lordship, I have applied for the order. It's supposed to come by this week.
The grave urgency.
Lordship, the urgency is that this is there's a pending application under section 34 of the Arbitration Act before the Learned Commercial Court. Whereas the award holders, they are proceeding to execute the award in Bombay. So, and the learned judge has fixed the date in July. I need Lordship, I need to prepone the date. I need to seek a Lordship. The other thing is, Lordship, the other, I have applied for the copy.
Yesterday,
Lordship, just one more thing. The deponent, he's flown in from Bombay last night and he's supposed to leave today. If your Lordship kindly lets me file it, affirm it without the certified copy, I shall file the form copy, the certified copy by Thursday.
To affirm without the certified copy, but to file with the certified.
Yes, grateful.
What undertaking?
Yes,
That is
yes, I have given that undertaking. It's a
that will
period.
file with the certified copy.
Yes, Lordship. Yes, Lordship.
With that undertaking.
Yes, with
My lord,
grateful Lordship.
yesterday item number 19, it was dismissed for default. Tomorrow, item number 19 yesterday, it was dismissed for default.
What
So
can
I
be
will,
done? You
no, I will file restoration, but the department had given me a number CO222 of 25, but the list is showing 1215 of 25. Which number will I give while writing the restoration? Two different number was given. This is the
দেখে নিন তো, verify করে নিন ওটা কোনটা। Yes.
Malas, item number 1146 of your lordship list, Malas monthly list. Malas, tomorrow is the date fixed for Malas hearing of 7 to application. My 7 for 7 to application. My hearing of 7 to application. Malas, my VA will be stuck up. Malas, defense will be stuck up on that day.
Hearing of 7 to application.
Because Malas, my 7-1 application has been Malas dismissed.
Nothing.
Malas.
Yes, call the list.
Malas, tomorrow Malas, my
Yes. Yes, call the list.
Item number 1, I am on behalf of the
My lord, I am the petitioner in this matter.
allegation with my client. No objection. Vocal number, no objection, not been done.
Yes. Why are you not giving no?
First,
Why are you not giving no objection?
my lord, I am ready. I am also ready. No objection. But dues are completed and no objection and certificate. There before the court below, my lord. This allegation.
All right, I'm
before the court below, my lord.
Yes, Mr. Ghosh,
Yes,
I'm keeping
serious,
it-
serious
I'm keeping it
allegation. my
tomorrow the learned advocate is present. Please sort out the problem because he has some demands. I'm keeping it tomorrow. Please sort out the problem in course of this day.
My lord,
Please.
my lord, I have.
Yes, please sort out the differences between you and your advocate.
My lord, I have already intimated to him. If you, if your lordship allows, then I may submit those all the proofs
No,
where
no.
I have requested him
I
to produce simple bills. There is no bill, my
Yes,
lord. That is.
I don't need to see this. Please sort it out in course of this day. I'm keeping it for tomorrow. Yes, tomorrow I will consider that. Yes. Call the next matter.
Your lordship,
My lord, I am for the opposite party, my lord.
I'm
Yes.
for the petitioner. Your lordship, our learned advocate, Mr. Vishwarup Mukherjee, is like attending in some other court. So can you kindly pass over this matter? Short pass over.
My lord, your lordship on the last occasion was pleased to say, my lord, to absorb that and fix this matter for disposal, my lord, because continuously they are filing such CO application and they are taking time, my lord.
Yes.
Keep the last order of Justice Sampath Sarkar, my lord.
Yes, where is Mr. Ghosh?
Your lord, I just need a short passover because our learned senior counsel is on his way. He's coming, your lordship. So
All right.
he's in court number 40. So
My lord, kindly fix a date for disposal, my lord.
Today it will be taken up at 2 p.m.
I'm ready.
grateful, your lordship.
2 p.m. Yes.
Item number 3, I'm appearing on behalf of the petitioner, my lord. Seeking, my lord, extension of the interim order, which has been initially passed on 31st January 2024 by Her Lordship, the Honorable Justice Shompa Sarkar. Thereafter, it has been extended from time to time, and lastly on, my lord, 25th March 2025, it has been extended till 1 week after vacation, my lord, summer vacation. I'm praying for an extension of the interim order.
I'm extending it for a limited period. I'm directing this matter to appear before the regular bench.
Acha.
This matter
for the petitioner that before vacation, but I could not appear, Your Lordship.
Yes, Mr. Shah.
Lord, Your Lordship, on the last occasion, observe that today Your Lordship will hear the main matter.
That is your other side. Oh, Mr. Banerjee is here. Main matter, why? It's coming up under the heading extension.
Yes. Before they are making allegation against us that we have suppressing facts, got the interim order. Last occasion, I have heard. Very short matter, my lord, I can tell. Within a minute, I can complete.
All right.
Lord, my learned friend filed a suit for eviction on revocation of license.
Sir, please adjust the microphone.
You also can't hear me. Lord, my learned friend filed a suit for eviction, alleging me as a licensee. We are the brothers, his brother's wife, and we are the brother-in-law. And thereafter, I filed a suit for partition. My prayer before Your Lordship is that both the suit may be heard analogously. That eviction suit may be transferred to the court before the senior judge where partition is pending.
What are the stages of both the suits?
Preliminary stage. Issue is.
What is the impugned order?
My client filed an application for stay of the eviction suit.
That was rejected.
Because the earlier suit cannot be stayed.
Yes, Mr. Banerjee, if both the suits can be clubbed together.
Or properly established. What claim my license or properly established. My suit is some suit on the ground of termination of license. But evidence has already been established. And
their suit.
They have started proceedings.
And in their suit.
Their suit, after about 1 year, after 5 years, is written a statement was the party. And
Mr. Banerjee,
22 other persons, not one impleaded, an application under section order 39 1 and 2 has been filed for the purpose of injunction against all the parties, and one of them was served, others were not served. This is the position.
The suit is not ready for hearing.
Suit is not ready, Lord, not served, and my case.
How then those can be clubbed?
Satisfy the court.
Mr. Shah, if that is the fact, how can it be clubbed? If Mr. Banerjee says there are other parties, the suit is not ready by service. That is Mr. Banerjee's submission. Your suit.
Let me take instruction of Your Lordship and make it next.
Because if that is so,
this suit of 2022.
Maybe suit of 2022. But the fact remains, if both the suits are almost at the same stage, they can be clubbed. But what I have heard from Mr. Banerjee is that there are several other parties also in your party.
Because this is co-sharers are there.
Yes. So if that is so, it might be a difficult thing altogether.
You take it next week. Let me take instance of that suit. What is the position?
After some argument, Mr. Shah
Lord, I appear for the petitioner. Yes. Lord, here, my lord, the initial question before your lordship was whether the Debts Recovery Appellate Tribunal could have disposed of a waiver application before condoning the delay for filing the appeal. My lord, the interesting question of jurisdiction was raised by my learned friend. And my lord, he said that
tribunal situated within one state and the appellate tribunal in another state.
Now, my
Which
lord,
High Court will have jurisdiction.
that's right. Now, my lord, there is, of course, my lord, some divergence of judicial view in this matter. Our High Court, my lord, Justice Bhaskar Bhattacharya has held that no, there's a difference between Article 226 and Article 227. Article 226, even if a minuscule part of the cause of action arises within the jurisdiction, and it will, because the tribunal is situated within the jurisdiction, then the High Court will have jurisdiction.
Sir, give me a minute.
But it says that there will be no supervisory powers so far as Article 227 is concerned, because, my lord, ultimately, it is the, my lord, continuation of the original proceeding, my lord, filed before the, my lord, tribunal situated at separate, my lord, seat. That was, my lord, the view expressed by Justice Bhaskar Bhattacharya. My lord, although, my lord, here, ultimately, my lord, the principal question that has been considered by the courts, I find, my lord, on a scrutiny of judicial decisions, is, my lord, what is the original cause of action? Now, my lord, steering away from, my lord, the other part of the controversy, my lord, here what Justice Bhaskar Bhattacharya has held, and my lord, that is the view of our High Court, is that, my lord, the original cause of action is, my lord, the Debts Recovery Tribunal which entertained the application. It may be outside the state of, my lord, West Bengal. But lord,
in your case, the tribunal is within the state.
No, in my case, the original tribunal is at Guwahati. That is, my lord, the difficulty.
Bhaskar Bhattacharya's judgment is against you.
That's it. It's against me. But, my lord, the distinguishing feature here, without going into, my lord, the question is, my lord, whether, my lord, ultimately this tribunal independently would have, my lord, jurisdiction, and, my lord, therefore the High Court would have supervisory question, my lord, confining my attention presently to Justice Bhaskar Bhattacharya's judgment. My lord, there, my lord, what the learned judge felt is that, my lord, ultimately the order, my lord, that was passed by the DRAT was, my lord, an order dismissing, my lord, a proceeding that was filed challenging the original of the order of the DRT. And so, my lord, by applying the doctrine of merger, it says it is really the continuation of the same proceeding. And we hence held that today, if the High Court exercises supervisory jurisdiction under 227, it will in fact be exercising supervisory jurisdiction over a tribunal which is under the supervisory jurisdiction of another High Court. Yes. But, my lord, here, my lord, factually, the distinction is, my lord, the appellate tribunal has not even considered the matter on merits. It has only, my lord, ultimately, my lord, while, my lord, when an appeal is filed, normally before the DRT, 3 applications are filed. Well, if there's a delay, my lord, first condonation application, then the application for waiver of predeposit, and finally the stay application. Now, my lord, normally, my lord, of course, my lord, the condonation of delay will have to be taken up, because unless the delay is condoned, the appeal does not, my lord, take life. My lord, in this case, what has happened is, my lord, the waiver application is entertained. Direction is made to deposit 25% of the entire, my lord, decreed amount.
Without condoning the delay.
Without condoning the delay.
So, impliedly, delay has been condoned.
My lord, that is one way of looking at it. But, my lord, the delay, my lord, the condonation application has not even been taken up. It was not listed.
Implied, that is the implication, Mr. Shah.
My lord, if my lord,
if it has been, the merits have been entered into, waiver comes when there is an appeal in the eye of law.
Yes, absolutely.
So, that implies that a delay has been condoned.
Yes, my lord, there are judgments of the court where, my lord, of course, this implication, as your lordship notices, has not been noticed and says it is therefore a matter of putting the cart before the horse. Now, my lord, if your lordship is pleased to, my lord, make this observation, then, my lord, I have no difficulty.
No. That is
no, my lord. But, my lord, in all fairness, I must tell your lordship that here, my lord, since, my lord, the appellate tribunal has considered the waiver application, directed deposit of, my lord, an amount as a condition for waiver, 25% of the total, my lord, decretal amount, and thereafter, my lord, proceeded to dismiss the appeal itself. my lord, because the amount, my lord, could not be deposited. My lord, that we are before your lordships. Now, my lord, two questions.
According to you, it's all, really challenging an order passed by the appellate tribunal not going into the.
That's right. Well, there is no question of merger here.
Yes.
Well, if there is no question of merger, then well, independent of all these considerations, well, it is only and only the order of the appellate tribunal which, my lord, ultimately requires scrutiny. There is no reflection back or dating back of the original cause of action, or of the, my lord, continuation of the original cause of action in the appeal, because there is no adjudication made. And there, I think, well, Justice Bhaskar Bhattacharya makes that distinction also. But if I may request your lordship to kindly.
Justice Bhaskar Bhattacharya's judgment is on this DRT matter.
Yes.
Mr. Shah, have you considered those line of decisions arising out of Income Tax Act?
I have seen those. Your lordship mentioned it on the last occasion. I have seen those.
Supreme Court judgments are also there.
Yes, I have seen those. Well, I am carrying those judgments. But, my lord, with the greatest of respect, my lord, there is again a divergence of opinion there. Well, Lord, one is
Supreme Court has finally, I think, in a recent decision, Supreme Court has resolved that. There was divergent views of different high courts. Thereafter, the Supreme Court has finally decided, and following that, we have taken a view. It's myself, with this Chief Justice bench, following that Supreme Court decision.
Well, I will check it up. My lord, it is
similar facts. Assessing officer is within the jurisdiction of one court.
No, it is now held.
And tribunal is within the.
No. Well, I am carrying the judgment. Assessing officer, wherever is the seat of the assessing officer, will have jurisdiction.
Yes.
Of course, my lord. That is, my lord, when your lordship is considering, my lord, the matter in the conspectus of, my lord, a challenge from the main.
Yes. You are trying to make a distinction.
Yes. I accept that position. Well, and that is also, my lord, the position set. I am carrying those judgments.
Yes.
Your lordship, my lord, was kind enough to indicate, my lord, I looked it up. That is the position of law. There is also, my lord, a different, my lord, line of Supreme Court judgments which says that ultimately the cause of action in such cases will be the cause of action of the order passed by the appellate authority because of the doctrine of merger. And now it is the order of the appellate authority. But it does not, of course, consider, my lord, as to whether, my lord, the appellate authority is, my lord, really, my lord, a continuation of the seat of the original filing of proceeding. My lord, that, of course, has not been considered. But, my lord, I do not want to, my lord, get into that fact. Because, my lord, I will proceed on the basis that, my lord, the assessing officer, or, my lord, in this case, the original DRT would be, my lord, the original, my lord, court for the purpose of, my lord, the consideration of the matter. In this case, one peculiar circumstance is that, my lord, the original petition, my lord, what your lordship is now considering under 227 was filed under 226. My lord, Justice Bhaskar Bhattacharya says very clearly that 226 can be entertained. Now, my lord, what the learned judge, my lord, did.
Yes, because it's not a supervisory. 226 is a different thing altogether.
Right. Now, my lord, converted into a 227, and my lord asked us to, my lord, come before the 227 court. Well, I'm not even, my lord, quarreling with that proposition because, my lord, what has happened has happened. We have not questioned that judgment. Now, my lord, if your lordship will kindly take up once, my lord, Justice Bhaskar Bhattacharya's judgment, my lord, that is.
Yes, Mr. Palchoduri, are you ready with this on this point? Because Mr. Shah is ready to.
I have considered it. If my learned friend wants time, my lord, I don't want to stand in the way.
I can hear Mr. Shah. If you are ready, you can make your submissions, or if you want to consider.
If my learned friend wants to take time, let him go. This is an interesting question.
Yes, that is why.
Well, if your lordship, my lord, wants to hear.
Have you also done some research work on this? So, Palchoduri, I indicated the points. I also gave both of you the line of decisions which are prevailing. You ought to have considered those, and Mr. Shah is ready with those points. You ought to have considered those. All right, let me hear Mr. Shah first. If you are ready, you can answer his points. You can. Okay.
Next week.
Next week. Or if Mr. Shah makes his point, then we will be. You can make your submissions on the other day, according to your choice. Let Mr. Shah make his submission so that We'll understand his points also.
My lord, may I request your lordship to kindly take up my lord Justice Bhaskar Bhattacharya's judgment first. My lord, that is 2002. My lord, it is All India Reporter 2002, Calcutta 223. Well, I think a copy was handed up to your lordship.
Was handed up.
Copy
2002, yes. Because it's an interesting point also.
Yes, yes.
It,
Yes, it is. It is. Yes. Let please see the first paragraph of the judgment. That will give your lordship under the understanding of what was the subject matter of challenge.
Yes.
This revisional application under Article 227 of the Constitution of India is at the instance of 4 of the defendants and is directed against an order dated June 1, 2001, passed by the Chairperson, Debt Recovery Appellate Tribunal, Calcutta, in appeal such and such, thereby affirming an order dated 28 March 2000, passed by the presiding officer of the Debt Recovery Tribunal, Patna. So, my lord, it's an order of affirmation of an order passed by the Debt Recovery Tribunal, Patna. My lord, this is, my lord, important because, my lord, I'm saying, my lord, as to how the concept of merger fits in.
Yes, so, Appellate Tribunal is in Kolkata and the tribunal is in Patna.
Yes, and my lord, the order is an order affirming the order of the Patna Tribunal.
Yes. So, the question of merger.
Yes, question of merger. Now, my lord, thereafter, my lord, kindly see very briefly, paragraph 2. There is no dispute that a title mortgage suit was, my lord, filed. My lord, this was disposed of on compromise. That is the first part of paragraph 2. My lord, then there was this challenge to the compromise decree.
Yes.
My lord, please, my lord, come to, my lord, paragraph 6.
Yes.
In the meantime, my lord, so compromise decree filed, my lord, on the basis of compromise decree, section 19 filed before the Debt Recovery Tribunal. In the meantime, the application filed under section 19 of the Recovery of Debts Act was taken up for hearing and a certificate under 19(7) of the Act was drawn up and sent to the learned recovery officer for its execution under sections 25 and 28 of the Act. Being dissatisfied with the order dated 28 March 2000, the petitioners preferred an appeal before the Debt Recovery Appellate Tribunal, Calcutta, alleging non-disposal of the prayer for setting aside the decree on the ground of fraud. By the order impugned in this application, Appellate Tribunal has dismissed the appeal preferred by the petitioners and affirmed the order passed by the tribunal. So it's an order of affirmation of the order passed by the tribunal. Then we'll look paragraph 10. After hearing the learned counsel for the parties and after going through the materials and record, I am of the view that this application under Article 227 of the Constitution of India is not maintainable before this court, as this court has no power of superintendence, either administrative or judicial, over the Debt Recovery Tribunal, Patna. Merely because the appellate tribunal is situated within the territorial limits of this court, such fact cannot confer jurisdiction to scrutinize an order passed by the tribunal in any appeal preferred against a decision of the original tribunal over which this tribunal court has no power of superintendence. It is an admitted position that the appellate tribunal constituted under the Recovery of Debts Due to Banks and Financial Institutions Act, though has its headquarters at Kolkata, such appellate tribunal exercises power over debt recovery tribunals functioning in the entire eastern region, consisting of Bihar, Jharkhand, West Bengal, Assam, Sikkim, and over northeastern states. In the instant case, the certificate sought to be impugned was issued by the Debt Recovery Tribunal, Patna. The compromise decree was passed by a court at Dhanbad, over which this court has no power of superintendence. Therefore, the entire cause of action, well, kindly note this, the entire cause of action leading to the issuance of the certificate has arisen beyond the territorial jurisdiction of the court. Well, important because, my lord, it is the issuance of the certificate that is, my lord, under scrutiny. The appellate tribunal is no doubt situated within the territorial limit of this court, but that fact cannot vest this court with authority to entertain this application, the object of which is to correct an order passed by the Debt Recovery Tribunal, Patna. Well, this is again very important. The object of which is to correct an order passed by the Debt Recovery Tribunal, Patna. The position would have been different if the petitioner had filed a writ application under Article 226 of the Constitution of India, which authorizes this court to interfere with any order passed by a tribunal situate within the territorial limits of this court, even though the cause of action has arisen in a different state. Well, this is the distinction that is made. Then, my lord, Article 226, 1 and 2 are noticed. My lord, Article 226, 2 is significant. The power conferred by Clause 1 to issue directions, orders, or writs to any government.
Cause of action wholly in part or outside. That is the.
Yes. And, my lord, 227 is thereafter also, my lord, ultimately reproduced. Then please come to paragraph 11. By virtue of Article 226 of the Constitution, this High Court shall have power to issue appropriate order, even if no part of cause of action arises within the territorial jurisdiction of this court, but the seat of authority whose order is challenged is within the territorial limit of this court. But language of Article 227 is different. According to such provisions, the High Court shall have power of superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction, and can call for returns from such tribunals, and may also make order, issue general rules, and prescribe forms for regulating the practice of proceedings of appeals against decisions of such courts and tribunals. If a tribunal is constituted as an appellate tribunal for hearing appeals against decisions of more than one original tribunal situated in different states, in my view, in such a case, for the purpose of challenging orders of such appellate tribunals by way of an application under Article 227 of the Constitution, an aggrieved party is to approach the High Court of the state within the territorial limit of whose original tribunal of which the original tribunal exercises jurisdiction in a particular case. A debts recovery tribunal may be constituted by conferring jurisdiction over more than one state. In such a situation, the High Court of those states will have power of superintendence over the tribunal, but depending upon the cases where cause of action has arisen within the territorial limit of a particular High Court. For instance, Guwahati Debts Recovery Tribunal has been given jurisdiction over Assam, Sikkim, and other northeastern states. If, in a given case, the cause of action arises within the territorial limit of Sikkim, in such case, Sikkim High Court will have power of superintendence, but in other cases, Guwahati High Court will have to exercise power of superintendence. This is very important in my respectful submission. If, in a given case, cause of action arises within the territorial limit of Sikkim, in such case, Sikkim High Court will have power of superintendence. But in other cases, Guwahati High Court will exercise power of superintendence. Now, here, the cause of action has arisen, in my respectful submission, entirely within the jurisdiction of this court. Because, my lord, it does not ultimately seek to, my lord, modify, alter, or even, my lord, keep as it is, my lord, the order passed by, my lord, the Debts Recovery Tribunal. It is an independent, my lord, exercise of jurisdiction by the appellate tribunal, my lord, which therefore, my lord, is subject to the scrutiny of, my lord, your lordship's, my lord, supervisory jurisdiction. My lord, this is, my lord, a very important part in my respectful submission, and, my lord, this is clarified in paragraph 12. In the instant case, if the appeal was preferred against the order of the Debts Recovery Tribunal, Kolkata, this court could be moved against any appellate order passed against such decision of such tribunal. But if an aggrieved person wants to challenge the order of the appellate tribunal arising out of an order of Debts Recovery Tribunal, Patna, the appropriate court is either Patna High Court or the Jharkhand High Court, depending upon the territorial limit within which cause of action has arisen in a given case. If this court entertains this application and sets aside the order passed by the appellate tribunal, and consequently the certificate issued by the Debts Recovery Tribunal, Patna, is modified, this court will be directly interfering with the order of a tribunal functioning beyond the territorial limits of this court. Therefore, before entertaining an application under Article 227 of the Constitution of India, the court must ascertain what is the effect. Court must ascertain what is the effect of interference prayed for in such application. If the result of such intervention is that an order of a tribunal over which the High Court has no power of superintendence will scrutinize, in such case the High Court should not exercise.
According to you, you are saved by this.
Yes. My lord, because, my lord, ultimately, my lord, it is, my lord, the very, my lord,
the order of the tribunal will be interfered with.
That's it. It is, my lord, the first principles which we have learned, my lord, from the very first days. My lord, an appeal is a continuation of the original proceeding. So, my lord, if today the order of the original court is interfered in the appeal, well, then one can say it is the order of the original court that is being interfered with. but my lord, there is no interference in this matter with the order of the original court or tribunal. So my lord, here, my lord, the cause of action arises within the jurisdiction. The supervisory power is the power of the High Court within whose jurisdiction the tribunal is situated, for the simple reason that my lord, ultimately it has not passed any order which my lord either confirms or reverses or my lord maintains as it or my lord modifies an order passed by the original tribunal. My lord, that is the distinguishing feature. My lord, even if we do not travel my lord to the other realms, my lord, this my lord is the order of our High Court, which my lord ultimately will have some my lord precedent value of precedence, my lord. So therefore, my lord, if one reads this judgment and my lord, this paragraph my lord amplifies, that is my lord, what is the scope of interference? Is it something that ultimately
What is the ultimate effect of the interference?
Yes, and my lord, this in my respectful submission is good enough. But my lord, your lordship, my lord, asked us to my lord, be more educated in my lord this aspect of the matter, and my lord, we have taken some steps. My lord, in one my lord view of the matter is, my lord, even when my lord, the doctrine of merger applies, and my lord, the order of my lord, the original tribunal has merged with the order of the original appellate tribunal. Ultimately, the appellate tribunal's order is my lord, the final order. And my lord, if that is the final order and the appellate tribunal is situated under the jurisdiction of any particular High Court, the High Court exercises jurisdiction. The other view is, as your lordships were pleased to point out, that ultimately, my lord, if the assessing officer is an assessing officer of another state, and my lord, the Central Board of Taxation, my lord, ultimately sits in appeal over that order, my lord, it is really a continuation of that order. That is also what Justice Bhattacharya has held. Now, my lord, there is no quarrel with this proposition. Well, I would, my lord, invite your lordship, my lord, to follow, my lord, the view that has been taken by Justice Bhattacharya. Because, my lord, to uncomplicate matters without, my lord, going into, my lord, an issue of resolving, my lord, two different points of view that have been taken by different courts, including the Supreme Court. My lord, the Supreme Court has also taken two different views, my lord, in different matters. But
Supreme Court has taken two different views.
yes, yes. Well, in one view, my lord, the Supreme Court is saying that the order of the appellate tribunal is, my lord, the final order. But again, my lord, the view expressed is in connection with, my lord, writ petitions, where, my lord, the question of, my lord, part of cause of action becomes, my lord, dominant. And there the courts have held, my lord, dominance lightest, wherever, my lord, if two courts have jurisdiction, you have the right to choose your court.
Yes, if part of cause of action, any court.
So, my lord, those decisions, my lord, since they are rendered in respect of writ petitions, and my lord, Justice Bhattacharya has, my lord, taken some pains to, my lord, make a distinction between 226 and 227. But I think that perhaps, my lord, a scrutiny of those decisions will not be there. My lord, this apart, my lord, Bombay High Court, Gujarat High Court, another High Court, Madras High Court.
Mr. Shah, since you have done a lot of research work through your team
Yes,
of juniors,
may I, my lord, first show your lordship?
Decision of the Supreme Court from 227 on in this line.
I know. Initially, well, 227 decisions are not there. All 226 decisions. So.
But yes, sir.
No, but the judgments against us, my lord, if I may show your lordship, my lord, some of the judgments, my lord, which are against us. My lord, of course, my lord, these are distinguishable. Well, I shall show your lordship, my lord, the Supreme Court judgment. My lord, this is, my lord, in the matter of, my lord, this is the, can you show the income tax matter? ABC papers. You're not carrying them?
So the one which you were supporting.
Oh, against decisions you're not carrying. My learned friend not carrying the decisions which are against us, but my lord, which found out
We
because
can screen share, Mr. if Mr. Saha and learned Honorable Justice wants, we can screen share. I am assisting Mr. Saha.
Yes, please then share the decision in the case of ABC papers.
Very well, very well. Just a quick moment. We are doing it right away. Grateful.
Should be allowed to screen share?
Yeah, if Mr. Court Officer may kindly allow us to screen share, that option if may be permitted.
They have allowed you. They have allowed. They have allowed.
Grateful. Apologies for the slight delay. We have found the judgment. Just a moment.
Yes.
Yes, Lordship, please.
May I request your Lordship to kindly have a look at paragraph 3. Please scroll up to paragraph 3.
What is the citation, Mr. Shah?
My lord, this is, my lord, from the Supreme Court website itself. My lord, I'll give you Lordship, my lord, the civil appeal number. I
Yes,
shall
yes,
make available the
civil
copy.
appeal number 4252.
4252 of 2022. Huh? Well, I'll have an hand over a copy, my lord, within the course of the day.
Yes, yes. Paragraph 3.
My lord, please have a look at, my lord, paragraph 1. My lord, since your lord, my lord, because this is the income tax judgment, I think your lordship was referring to.
Yes, yes.
These appeals give rise to an important question concerning the appellate jurisdiction of the High Courts under Section 260A of the Income Tax Act 1961 against judgments of income tax appellate tribunals. As benches of ITAT are constituted to exercise jurisdiction over more than one state, each state having a separate High Court, question arose as to which of the High Courts is the appropriate court for filing appeals under Section 260A. The question arose because Section 260A is open textual and does not specify the High Court before which an appeal would lie in cases where tribunals operated for plurality of states. This question came to be conclusively answered by the High Court of Delhi in the case of Said Banarasi Das Gupta versus Commission of Income Tax, wherein it was held that the appropriate High Court would be the one where the assessing authority is situated. The judgment continues to hold the field. And thereafter, my lord, if your lordship will kindly see paragraph 3 once, please come to paragraph 3. Having considered the matter in detail and while reversing the judgments of the Delhi High Court in Sahara and RB, we have also held that the appellate jurisdiction of the High Court stands on its own foundation and cannot be subject to the exercise of executive power of transfer of a case from one assessing officer to another. My lord, this is not a separate question, but my lord, these were the two questions which had fallen for consideration. And then, my lord, if your lordships will kindly have a look at paragraph, my lord, 14.
14.
Yes. Insofar as appeal to a High Court is concerned, it is Section 260A which provides that an appeal shall lie from every order of the ITAT. Section 268 is, to the extent relevant, is as under, then the section is reproduced. As is evident from the above, Section 260A is open textual and does not specify the High Court before which an appeal under 260A of the Act would lie. Even Section 269, which defines High Court, merely relates the High Court in any state with the High Court for the state and further prescribes specific High Courts for each of the Union territories. It is this uncertainty about identification of the appropriate High Court for filing an appeal against an order of ITAT exercising jurisdiction over one state that we are called upon to decipher and declare. Then please see paragraph 17. Keeping the above principle in mind, we will now return to the inquiry into the appropriate High Court for filing an appeal against an order of a bench of the ITAT exercising jurisdiction over more than one state. We notice that the issue has already fallen for consideration before a division bench of the High Court of Delhi way back in 1978 in the case of Said Banarasi Das Gupta. Having considered the matter in detail, the High Court of Delhi held that the most appropriate High Court for filing an appeal would be one where the assessing officer is located. The decision was followed in Suresh Desai by Justice Lahoti and provided additional reasons in support of the same view. The imperative choices are based on the following reasons. Well, I shall ignore, my lord, reasons 1, 2, 3, 4. Please see 5. In view of the doctrine of precedence and the rule of binding efficacy of law laid down by a High Court within its territorial jurisdiction, a question of law arising for decision in a reference should be determined by the High Court, which exercises territorial jurisdiction over the situs of the assessing officer. Well, this was, my lord, what prevailed with, my lord, the Supreme Court, and Supreme Court ultimately accepted the view expressed by the Delhi High Court. Rest of the judgment was, my lord, on the aspect of transfer. So, my lord, that may not be very relevant. Well, this apart, my lord, there are, my lord, a couple of other judgments.
This is also on 260 capital. It's a statutory appeal.
Yes, statutory.
So not 226 and 227.
No, but my lord, at the same time, the, my lord, underlying principle which your lordship gathers from that part of section of clause 17 of this judgment, para 17, is that when ultimately, my lord, if the question of law is to fall for consideration of the supervisory High Court, then, my lord, the assessing officer being, my lord, the place where the proceeding initiated or originated is the court of appropriate jurisdiction.
Accepting this, it would be the original tribunal.
Yes.
But you are trying to make a distinction because the tribunal's order will not
That's
in
right.
way be interfered with, even if a decision in this civil division application goes in your favor.
That's right. That's right. And that is, it's not an absolute proposition which Justice Bhattacharya has laid down. Justice Bhaskar Bhattacharya has said that you must look at what is the ultimate effect of your interference. If it relates back to the original proceeding and ultimately affects the original proceeding over which another high court would have supervisory power or jurisdiction, then you should not. Otherwise, it does not say there is an absolute bar. That is the distinguishing feature. There are otherwise also other judgments of the Supreme Court which creates some amount of confusion in this regard. But again, I must say that this is in respect of writ. Now, since Justice Bhaskar Bhattacharya has
This is in
himself
respect of writ.
yes, 226.
So, Shah, it's better because since this issue is to be decided, it's better to have
No,
all
I
views together.
shall cite it, I shall cite that decision. Because, there is also that view where your lordships have, expressed times without number, that 226 and 227 are, somewhat, overlapping.
Yes.
In, their reach and approach. And so, therefore, very strict or, pedantic construction of these provisions is not, ultimately adhered to. That, number of decisions on that, I don't want to trouble your lordship with that. But, at the end of the day, please have a look at, the judgments, which, I say judgments in favor. The first decision is one of the Supreme Court itself. This is 1962 AIR 1963 Supreme Court 1124. I shall hand up a copy,
1124.
1124.
Yes.
May I just read from the first paragraph? I'll not read the entirety, but the facts are required. This is an appeal on a certificate granted by the Calcutta High Court. The brief facts necessary for present purposes are these. The respondent had imported 2,000 drums of mineral oil. Out of this quantity, the appellant, the Collector of Customs, Calcutta, confiscated 50 drums by order dated such and such. He also imposed a personal penalty of rupees such and such on the respondent under the Sea Customs Act. The respondent appealed to the Central Board of Revenue under Section 188 of the Act, and this appeal was dismissed in April 1952. Thereupon, the respondent filed a petition under Article 216 of the Constitution in the High Court. We are in the present appeal not concerned with the merits of the case put forward by the respondent, for the matter has not yet been heard on merits. When the petition came up before a learned single judge, a question was raised as to the jurisdiction of the High Court to hear out the petition in view of the decision of this court in Election Commission of India versus Venkata Subbarao. As learned single judge considered the point important, he referred the matter to a larger bench, and eventually the question was considered by a full bench of the High Court. The full bench addressed itself to two questions in that connection, namely, whether any writ could issue against the Central Board of Revenue, which was a party to the writ petition and which was permanently located outside the jurisdiction of the High Court, and whether, if no writ could issue against the Central Board of Revenue, any writ could be issued against the appellant, which was the original authority to pass the order under challenge, when the appellate authority, namely the Central Board of Revenue, had merely dismissed the appeal. Well, then please come to paragraph 3. The only question which falls for decision before us is the second question debated in the High Court, namely, whether the High Court would have jurisdiction to issue a writ against the Collector of Customs, Calcutta, in spite of the fact that his order was taken in appeal to the Central Board of Revenue, against which the High Court could not issue a writ, and the appeal had been dismissed. There seems to have been a difference of opinion amongst the High Courts in this matter. The Rajasthan High Court in Barkat Ali had held that the original authority passing the order was within the jurisdiction of the High Court, but the appellate authority was not within such jurisdiction. The High Court would still have jurisdiction to issue a writ to the original authority, where the appellate authority had merely dismissed the appeal, and the order of the original authority stood confirmed without any modification. On the other hand, the Pepsi High Court in Joginder Singh and other judgments, and the Allahabad High Court in Azmatullah held otherwise, taking the view that even where the appeal was merely dismissed, the order of the original authority merged in the order of the appellate authority, and if the appellate authority was beyond the territorial jurisdiction of the High Court, no writ could issue even to the original authority. It may be mentioned that the Rajasthan High Court had occasion to reconsider the matter after the decision of this court in Musaliar, and held that in view of the decision, its earlier decision in Barkat Ali was no longer good law. The High Court, however, has noticed that the later decision of the Rajasthan High Court, to which the learned Chief Justice, who was a party to the other Rajasthan High Court case, was also a party. Then, my lord, kindly ignore this. Please come to the next paragraph. The question therefore turns on whether the order of the original authority becomes merged in the order of the appellate authority, even where the appellate authority merely dismisses the appeal without any modification of the order of the original authority. It is obvious that when an appeal is made, the appellate authority can do one of three things, namely, 1, it may reverse the order under appeal, 2, it may modify that order, 3, it may merely dismiss the appeal and thus confirm the order without any modification. It is not disputed that in the first two cases, where the order of the original authority is either reversed or modified, it is the order of the appellate authority which is the operative order, and if the High Court has no jurisdiction to issue a writ to the appellate authority, it cannot issue a writ to the original authority. Well, this is a very important part. The question, therefore, is whether there is any difference between these two cases and the third case, where the appellate authority dismisses the appeal and thus confirms the order of the original authority. It seems to us that on principle, it is difficult to draw a distinction between the first two kinds of orders passed by the appellate authority and the third kind of order passed by it. In all these three cases, after the appellate authority has disposed of the appeal, the operative order is the order of the appellate authority, whether it has reversed the original order or modified it or confirmed it. In law, the appellate order of confirmation is quite as efficacious as an operative order as an appellate order of reversal or modification. Therefore, if the appellate authority is beyond the territorial jurisdiction of the High Court, it seems difficult to hold that even in a case where the appellate authority has confirmed the order of the original authority, that the High Court can issue a writ to the original authority, which may even have the effect of setting aside the order of the original authority when it cannot issue a writ to the appellate authority, which has confirmed the order of the original authority. Well, this is the confusion. Well, these are the two different views. In effect, the issuing writ,
and this is against the full bench of our High Court.
Yes. Yes, it is. It is. But my lord, if my lord one does not look into the doctrine of precedence, but my lord applies my lord common sense, I am my lord more inclined to my lord accept the view that Justice Bhaskar Bhattacharya has put forward. Because my lord, ultimately my lord, two very fundamental principles. One is, my lord, appeal is a continuation.
It is also a distinction because what you are trying to submit is, at this stage, there is no question of merger. Because but appeal has been dismissed. In your case?
No, my lord, dismissed on the ground. My lord, this is very important. Dismissed on the ground of non-payment of, my lord, the amount of deposit. My lord, not on merits. It is not an order of confirmation in that sense. Well, that distinction, my lord, is required to be made. Because, my lord, today, if your lordship sets aside this order of dismissal, your lordship will not in any manner impact, my lord, the original order of the tribunal. Your lordship will be merely asking, my lord, the tribunal to, my lord, either, my lord, treat this, my lord, as a, my lord, disposal of the application for condonation of delay itself, impliedly, or, my lord, remit it back to, my lord, the district tribunal to say that, no, first you decide the application of condonation, and then if you condone the delay, then decide the waiver.
Mr. Shah, what will be the effect if it is ultimately held that the effect of the order is allowing your application for impliedly allowing your application for condonation of delay?
Well, we have,
and thereafter rejecting dismissing the appeal on the ground of non-satisfaction of the pre-deposit or the prerequisite.
No, then, my lord, the pre-deposit question will come up once again. My lord, because, my lord, there would be no question, my lord, that I think we are covered by ample authority. Because, my lord, you just cannot put the cart before the horse. It would not work. My lord, so, my lord, the appeal has to, my lord, take life after the condonation of the delay. Then the question of pre-deposit. If I do not make the pre-deposit, even then another question comes. My lord, when it says the appeal will not be taken up for consideration, but will not be dismissed. I may not, my lord, seek to, my lord, have the happy appeal heard, or may not seek, my lord, stay of operation of the impugned order. My lord, that is also, my lord, their set of decisions, but immediately your lordship is not concerned with that. But, my lord, to answer your lordship's query, interestingly again, my lord, if today, my lord, the application, your lordship sets aside, my lord, this order, which dismisses the appeal, is your lordship in any manner, my lord, confirming the order of, my lord, the Debt Recovery Tribunal? No. Is your lordship, my lord, interfering with the order of the Debt Recovery Tribunal? No. Your lordship is merely interfering with the order of the appellate authority. And, my lord, this is, my lord, perhaps the clearest case under 227, where it says that no, how can you do something which you have not yet acquired the jurisdiction to do? That, my lord, jurisdiction you vest unto yourself once you ultimately condone the delay. Till you condone the delay, you're only hearing the application as to whether the appeal will be admitted. It is only when the appeal is admitted that the question of pre-deposit arises. It is only when the question of pre-deposit arises that the question of waiver of pre-deposit arises.
And everything will come in after the delay has been condoned.
Yes. And that is also the view of, my lord, various high courts in this matter. But, my lord, we, my lord, went on to a further, my lord, deeper question here. My lord, very interestingly, my lord, if we accept the two, my lord, very fundamental principles with which we have grown up, one is, my lord, an appeal is a continuation of the proceeding. And therefore, my lord, ultimately, even if the appellate court passes a decree, it is a decree which is really passed by the, my lord, lower court, which is being confirmed by the appellate court. But, my lord, the execution of the decree goes back to the lower court.
Yes.
So, my lord, if we remember that principle, then, my lord, a confirmation of, my lord, a decree passed by a lower court or by a tribunal, by the higher court or the appellate tribunal, will go back for execution before the lower court. So, my lord, it is the lower court's jurisdiction that is, my lord, maintained.
Yes.
So, my lord, if we accept that, my lord, principle as one of the, my lord, founding principles, my lord, of the procedures that we have grown up with, then, my lord, that is the correct view. And secondly, my lord, the question of the doctrine of merger. My lord, again, very important. My lord, the question is what merges into the appellate decree. Now, my lord, the doctrine of merger is against one of the very founding principles with which we have, my lord, grown up. And, my lord, it is only when there is ultimately a, my lord, coming
final adjudication.
Yes.
Not at the interlocutory stage.
Yes, and, my lord, that is exactly, my lord, paragraph 12 of Justice Bhaskar Bhattacharya's judgment. My lord, there, my lord, his lordship has, my lord, very consciously made that, my lord, distinction, not an absolute bar. Look at what is the end result of the supervisory jurisdiction that you exercise.
Mr. Shah, please show me the orders of the tribunal and the appellate tribunal.
Yes, my lord. My lord, please see, my lord, my lord, first, my lord, there are three applications that were filed. My lord, first, of course, is the condonation application. Then, my lord, the waiver application and stay application. Now, my lord, please see the first order of the tribunal that your lordship will find at page 41.
41 is first volume.
41 is first volume.
Yes.
The paragraph 3, instant appeal is preferred with a relief to set aside the judgment of the learned DRT Guwahati in OA such and such, jointly and several liably. My lord, this is the total amount of the, my lord, debt which is decreed 8 crores 49 lakhs, etc. And then, my lord, paragraph 4, learned counsel for the appellant submits that the amount of pre-deposit may be reduced to 25%. My lord, because that is, my lord, the statutory limit beyond which, my lord, the DRT cannot be. Then, my lord, if your lordship sees paragraph 5, my lord, UCO Bank's judgments referred to in paragraph 6. Since the appellant himself was prayed for reduction of the amount from 50% to 25%, and the certificate amount was 8 crores 49 lakhs 31,576. Simple interest which comes to approximately 8 crores 55 lakhs. Accordingly, appellant is directed to make a pre-deposit of 25% of 8 crores 55 lakhs within a period of 4 weeks. My lord, this is the first order, and then, my lord, please see page 46. Compliance with the order dated 5th July regarding pre-deposit is not made, thus the appeal is not maintainable for want of pre-deposit, and my lord, dismissed.
Yeah. So since you did not comply with the earlier order of pre-deposit, it was dismissed
now,
as
my
not
lord.
maintainable.
Well, I find that, my lord, it was at our invitation that this order was made. Well, at 25%. But, my lord, very importantly, my lord, kindly see, my lord, my lord, matter in a more realistic sense. My lord, 25% of 8 crores 55 lakhs is more than 2 crores of rupees. 2 crores of rupees is paid as pre-deposit. Then, my lord, the appeal is, my lord, dismissed because the delay is not condoned. My lord, there is no way of, my lord, ultimately recovering, my lord, this money. So, my lord, this is perhaps, my lord, due to, my lord, the procedure followed by the tribunal that the...
Mr. Shah, you invited the appellate tribunal for waiver. You moved that application.
My lord,
Move that
no, my
application
lord, the
for waiver.
condonation application. No, I quite appreciate that. My lord, but the condonation application was not even listed on that date, not heard.
We would not insist taking up that prior to, because it was at your insistence
No, well,
that
I'll tell your lordship what happened. My lord, your lordship will have to, my lord, perhaps take a more realistic view of how things move. But on this particular day, on which, my lord, the order of directing
this
pre-deposit
order,
was made.
the first order, was in presence of both sides.
My lord, in the presence of both sides, but, my lord, on that day, the waiver application was not even listed. My lord, we have annexed the copy.
Initial.
Yes. My lord, that your lordship find at page 45, we have annexed the cause list.
No, this is, what is IF 322?
My lord, the waiver application is, my lord,
322.
IA 322.
Yes, that was listed for admission. It says
no, my lord, IA
first line of the order.
My lord,
Page
please,
41.
My lord, please see page 45 once. Well, this is the
Come
cause
to
list
page
of it.
41 first.
Yes, yes. Page 41.
41, this 322 has been listed for admission.
My lord,
That is your waiver
my lord,
application.
Order has been made in the waiver application.
Yes.
But, my lord, on this date, my lord, this is on the 5th of July. Please turn the page to page 45.
45.
This is the cause list.
Oh, yes.
My lord, the waiver application was not in the list. My lord, please see item number 4, 321, 323, 392. Well, 322 was not listed. But, my lord, as a matter of, my lord,
Mr. Shah, that is a technical part.
No, my
In presence of both sides, both parties were heard, and you have invited, you have made that application.
My lord, only question is, this, my lord. Ultimately, my lord, then, my lord, the delay will have to be deemed to have been condoned.
Yes.
My lord, as your lordship has fallen from your lordship.
Impliedly condoned.
Yes, but, my lord, that is not there. Now, my lord, impliedly condoned, if your lordship, my lord, helps, my lord, I shall, my lord, if your lordship extends the time, I shall have to make the pre-deposit and go. But, my lord, otherwise, the predicament is this. My lord, I make the pre-deposit, delay is not condoned, appeal is dismissed. My lord, what happens, my lord, to the pre-deposit I make? My lord, this becomes, my lord, the bone of contention. And, my lord, ultimately, my lord, your lordship is aware that, my lord, the client is not before the court. It is, my lord, the advocate, my lord, and very often under, my lord, the procedure that is adopted by the court that, my lord, goes ahead and make the submission, and statutory minimum has been given. But, my lord, the only...
Please come to section 18.
Section 18. DRT Act. DRT Act ছিল তো
Yes, you can take this.
Yes, Jamal, I have it. Security system.
No, security system, surface here. Section 18.
Yes.
That pre-deposit.
Yes, madam.
Second proviso. 18.1.
Yes, madam. Hey, you can down now.
You have not got? Yes, please. It is dinner.
I'm sorry, madam. Very great.
Right hand page. Second proviso, 18.1.
Different fees may be prescribed for filing an appeal by the borrower or person with the guarantor, provided no appeal shall be entertained unless the borrower has deposited.
Yes, what is the meaning of this expression, shall not be entertained?
My lord, shall not be entertained has, my lord, been the subject matter of some, my lord, judicial, my lord, some decisions, my lord, where it says, my lord, shall not be entertained will not be not considered. But, my lord,
what is the effect of that? Will that appeal be kept pending for years together? Let us take a hypothetical case. An appeal is filed. and a direction was passed. You have the appellant did not make any application for waiver. It appears before the tribunal. Tribunal directs deposit of that pre-deposit amount not complied with. Appeal will continue to remain in the docket of the tribunal for years together.
My lord, it should not, my lord, ultimately uselessly around the, my lord, docket of the tribunal, but my lord.
So the effect is has to be dismissed one way or the other. May not be on merits. You may say that the question whether merger applies or not is one thing, but the appeal should not be kept pending.
Let me accept your lordship's view. My lord, appeal will not be kept pending. My lord, let me accept that view. Although, my lord, there is a different, my lord, view expressed by other high courts.
It will be kept pending.
No, my lord, it says, my lord, what will happen is, my lord, I can then, my lord, revive the appeal by making the
yes, you can revive. Even it is, I'm not saying you cannot revive that. But
no,
revival will be by way of an application. You have to cite reasons why it did not take place for this, explain. It's up to the tribunal whether to allow you, whether to revive it or not. I'm not saying it cannot be revived.
My lord, previously, my lord, amendment of the statute.
With Lordship's permission, may I assist learned senior Mr. Saha? And may I request to tender the judgment of Sai Enterprises and others versus DRAT? If Ramendu, you may kindly tender and assist learned senior Mr. Saha with Sai Enterprises judgment. I believe Lordship's query will be satisfied.
So this is Allahabad.
Paragraph 7, 8, and 9 on the proposition that for want of pre-deposit, appeal cannot be dismissed. It may not be proceeded further, but it may also not be dismissed. Apologies for the interjection.
I'll just ask my learned friend to, my lord, wait for a little while. My lord, I said, my lord, as I've told your lordship, my lord, that is the view of other high courts.
Yes.
My lord, it cannot be dismissed, my lord, but of course, my lord, it will not be entertained. My lord, which means, my lord, it will not be taken up for consideration. My lord, the other high courts will have had so. My lord, there is no decision of the Supreme Court on this. But my lord, when your lordship says, will it then be kept pending indefinitely? My lord, the difference is only this. If it is dismissed, well, in that case, there is no scope of reviving the appeal by making the pre-deposit, even upon making an application and citing cause. My lord, the cause here is, my lord, economic duress. I could not make the pre-deposit because I don't have the money. I have gathered the money, now I've made the deposit and can pursue the appeal.
Yes.
So, my lord, that is the essential distinction. So, my lord, here, my lord, the statute uses the expression will not be entertained. Does not say will be dismissed. My lord, that is the difference because, my lord, it affords an opportunity to, my lord, a person who is, my lord, under economic duress, not in a position to prefer the appeal, to, my lord, come back and do it later. Because the initial, my lord, provision of the statute was that you can waive the entire amount to pre-deposit in a deserving case. Then, my lord, the statute is amended to say that minimum 25%. So, my lord, that is the view. So, I shall come to those questions later. But, my lord, initially, to address your lordship on this, my lord, importantly, what is important is, my lord, here, therefore, my lord, ultimately, if the appeal, my lord, here the appeal is dismissed. If the appeal is dismissed, those doors are closed forever. So, my lord, I'm looking at the present order. First, my lord, thing is, my lord, so far as the waiver is concerned, my lord, the waiver application is not on record. Second, it is taken up, my lord, in the presence of the parties, even though it is not on record. And, my lord, ultimately, my lord, the waiver application is, my lord, allowed by, my lord, waiving 75% and directing payment to 25%. But, my lord, saying that it will have to be complied with. Delay not condoned. Well, if the delay is, my lord, not condoned, the appeal is not borne. So, my lord, here, therefore, your lordship will have to infer that, my lord, here there is a condonation of delay.
Yes, Mr. Palchodri. What do you say with regard to the implication of taking up the waiver application prior to condonation of delay? Please adjust your microphone. No, I'm not. Pre-deposit comes after. I'm not on pre-deposit. I'm only on condonation. What is your submission with regard to condonation? Whether that has been, delay has been condoned? কি মাইক্রোফোনটা কাজ করছে না? Microphone is not working, Mr. Shah. Yes.
Copy এটা বের করে দেন। Kindly come to page paragraph 9.
9, yes.
Citation to come to বলো
2011 for SCC 4 SCC 548.
Yes. Paragraph 9.
Paragraph 9, madam.
Yes.
The argument of the dates due has not been determined. The dates required tribunal, the appellate tribunal could not entertain by the appellate tribunal without insisting on pre-deposit. It's a question of fallacious. Under this second proviso of this subsection 1 of section 18 of the Act, the amount of 50%.
Oh, Mr. Palchodri, I think I could not make myself clear to you. My query is not that without the pre-deposit, it can be entertained. My query is not that. An appeal has been filed in this case with a delay. Now, an application for condonation of delay has been filed. An application for waiver of the pre-deposit to that 50 to 25 has been filed, and a stay application has been filed. These 3 applications were filed along with the appeal. Now, according to Mr. Saha, the condonation of delay was not taken up for hearing. Delay has not been expressly condoned. That is what Mr. Saha's submission. And at that stage, an order was passed on the waiver application, fixing a time limit to deposit that the pair of waiver was allowed and asking them to deposit. They could not deposit or did not deposit according to you. Accordingly, it was dismissed. Now, there are 2 things. Whether, my first question to you is, whether an application for waiver could have been taken up by the appellate tribunal prior to condonation of delay.
Yes, madam. Prior to.
Can be taken up.
Prior to.
Do you have any authority in this regard?
Authority, but practice is there prior to take
Practice is a different thing, because the second proviso of section 18(1) says appeal shall not be entertained. This appeal presupposes a live appeal, and unless a delay is condoned, the appeal has no existence in the eye of law. So the expression appeal shall not be entertained has to be read an appeal which has existence in the eye of law, not an appeal which has no existence in the eye of law.
No, my lord, there is
prior to condonation of delay, prima facie, my view is there is no existence of any appeal in the eye of law. Because when they came up for the extension, Mr. Shah's junior was there. I put a question to him. If there is no appeal in the eye of law, where is the question of passing any interim order? So if that is so, where is the question of directing pre-deposit to be made? That stage has not yet reached.
My lord,
you have any authority to so that condonation also has to be considered after the deposit is made? Cannot be.
No, I have not such authorities.
That says shall not be entertained, as rightly said by Mr. Shah, that it will be kept pending. It will remain. It will not taken up. It will not be taken up for consideration. If that is so, there are 2 ways of looking at it. What is the period of delay? Are you seriously opposing the delay? What is the period of delay, Mr. Shah?
30 days, 45 days, my lord. 45 days. From the
period of, I'm not of the statutory period.
Delay,
what is the length of the delay?
I don't have the condonation application with me, my lord.
Your juniors must be acquainted.
Yeah, I will try to find out, my lord. I'll try to find out. Well, here,
enormous or
just to assist learned senior Ramendu, we had filed a supplementary affidavit whereby the condonation application was there.
What is the period of delay? Supplementary affidavit.
Yes.
Mr. Palchodri, are you seriously opposing the condonation part?
Yes, my lord.
Condonation of delay part, are you seriously opposing?
Yes.
What is the period of delay?
Is more
Without
than
knowing the period of delay, you are saying I am opposing.
more than 500 days.
More than
May I assist, my lords? My
Yes.
lords, the period of delay from the knowledge of the decree is 137 days.
137.
But if my lord takes the period of delay from the actual passing of the order, then it comes out to be 739 days. So from knowledge 137 days, from actual passing out
relevant because for the applicant, it has to be from the date of passing of
No,
the
no,
order.
that's right, my lord. I can then explain away, my lord, with my
No,
lord.
that is a different thing. So the period is enormous, so he may not agree to that. I was thinking in other way.
Yes, I can understand.
Delay could have been condoned, then
Yes.
May I, with lordship's permission, may I point out that the requisite DRAT rules also provide that the impugned decree of the DRT ought to be provided to the litigant. In this case, this legal procedure has not been followed, my lords.
Yes, Mr. Palchodri, what do you say? Are you ready with this, or you want time to meet the submissions of Mr. Shah?
Well, a condonation of delay, my lord, there are 3 judgments which says, my lord, you can't take up the application for waiver before the application of condonation of delay. I'll give you, your lordship, my lord, the citations of those judgments.
I think that does not, but you have,
yes,
since you are carrying, please.
Yes, yes, my lord, I shall give you. I shall just, my lord, give you.
Mr. Palchodri, what is your, the delay has not been condoned expressly by any order. That then waiver application could not also have been taken up for hearing. So it's an error of jurisdiction which has been committed by the appellate tribunal. Then the question crops up is whether 227 can be entertained by this court only against that part of the error of jurisdiction by the appellate tribunal, not really touching upon the original order of the tribunal.
Yes.
Where is the order of the tribunal, DRT?
Well, the order of the tribunal, well, that is at, if your lordship sees, that is at page 55.
Second volume.
Well, second volume. The applicant is the defendant number 5 in the section 9 application, page 55. And the decree is at page 52. It was ex parte against, my lord, these defendants.
Oh, it was ex parte?
Yes.
You are the defendant number 5.
It was ex parte against the defendant number 5. And the cases, my lord, ultimately they say the notice was served, my lord, at the premises, which by the time of service of the notice had already been taken over by the bank under the provisions of the Securitization Act, physically taken over. That is, my lord, the ground.
So your case is of non-service of summons also?
Yes.
Then it has to be from the date of the knowledge. If it is a case, your case is of
no notice. No notice.
Service of summons.
Yes.
But what will be the period of limitation? Because you are not on Order 9 Rule 13. That distinction will be in Order 9 Rule 13. But appeal, I think, from the date of the decree. Let us take an example of an ex parte decree.
Yes.
If you apply under Order 9 Rule 13, there are 2 periods of limitation which operate. If it is non-service of summons, from the date of knowledge. If it is service of summons, thereafter for certain reasons, you did not, then from the date of the decree. But if you file an appeal against the ex parte decree, then it will be from the date of the decree.
Yes, but of course, my lord,
you can explain
explain
that is the different thing altogether. But the limitation will be one.
Yes.
It will be starting from.
Of course. But ultimately,
there is no provision for order akin to Order 9 Rule 13 here.
No, my lord. I shall check up once again, but my lord, as a, my lord, if my memory
cases of non-service of summons.
Yes.
Mr. Shah, what the appellate tribunal will do, in such a case?
Well, the appellate tribunal, my lord, will, my lord, ultimately say, my lord, because, my lord, even
because appellate tribunal, your defense will not be there before the
normally, my
appellate
lord,
tribunal.
provision would
So
be,
you have to challenge the propriety of the order on the basis of materials which are only available on record.
yes. But, my lord, unfortunately, my lord, I have not even been given the opportunity of filing a written statement.
Sir, Mr. Shah, your case
Order
is
9
of
Rule 30,
non-service.
yes,
Your case is of non-service.
yes.
So if it is a case of non-service, if there is any provision akin to Order 9 Rule 13, I think that's the best option. Because when you are preferring an appeal, you do not have your defense in the appellate tribunal. You have to succeed on the basis of materials which are only available before, or which were only available before the tribunal.
I understand.
It's a restricted scope of inquiry.
I understand. I understand. But I am not very sure, my lord. I have not, my lord, looked into the DRT Act to, my lord, find out as to whether the Act or the rules provide for, my lord, some similar mechanism. I will do so. But, my lord, we have preferred an appeal and not, my lord, sought any other
No,
recourse.
appeal, there is no bar in preferring an appeal.
Yes.
Even in Order 9 Rule 13, you can
Yes.
proceed simultaneously.
Yes, yes.
Too.
That's right.
But you have a right of appellate remedy, you can prefer. But usually, if it is a case of non-service of summons, it's better to.
In a civil proceeding, of course, that is what we would normally do.
Here also, because you will not have your defense. Appellate tribunal will, I think, appellate tribunal cannot allow you to file your pleadings.
No, my lord, if the appellate tribunal, what the appellate tribunal can do, subject to correction, is, my lord, set aside, my lord, the decree.
On what ground? Non-service of summons.
Yes.
But if
I understand.
fail on that, then you have to only succeed on the basis of the materials. You have to show that why this order could not have been passed, decree could not have been passed, even on the basis of the materials which were already on record. So the scope of inquiry will be much narrower.
Yes.
Because you don't have your defenses there.
Yes, my lord. I quite appreciate. But I have honestly not, my lord, looked into this, but I will, my lord, consider it once now that your lordship has.
That is the other part of this.
But, my lord, on the aspect of, my lord, condonation.
Where are those
Yes,
decisions?
my lord, the 3 decisions. I shall just first give your lordship the Sai Enterprises 2024 SEC Online Bombay. Well, the first decision is, my lord, 2024 SEC Online Bombay.
Page.
Well, it is 2024 SEC Online Bombay 2924. That is the first judgment.
Yes.
The second judgment is, my lord, no, this is not this is a different matter. Well, I'll just give your lordship the copies, and, my lord, the second one is 1970.
Give the references, you can give your compilation on the next day.
Yes, my lord. 1979 SEC Online Madhya Pradesh 142. And, my lord, 2013
142.
Yes.
And
2013 SEC Online Andhra Pradesh 85.
85.
Yes, ma'am. Madhya Pradesh.
All right.
Andhra Pradesh, Bombay to picture. No, Bombay to Madhya Pradesh issue, Andhra Pradesh issue.
Yes, Mr. Chappal Chaudhary, when
with prior permission, may I only seek the permission to add one more citation with prior permission, which is 2024 SEC Online SC 1878. My lord's a landmark judgment SC 1878.
SC
1878.
Yes, my lord. 2024 SEC Online SC 1878.
1878.
Well, that is on, my lord, the question of the length of delay. But, my lord, the propositions, my lord, on the aspect that, my lord, condonation, my lord, will have to be first heard. My lord, that is, my lord, there are 3 judgments.
Yes, because here we cannot be on the length of delay.
No.
It's only on the whether it could have been taken up prior to waiver application.
I'll make a compilation of these judgments and
yes. Then I'm doing one thing. I'm giving all the decisions. You can make a compilation and.
Yes, ma'am. But if your lordship has marked any of the decisions, lordship may keep it. I know what decisions have been cited. I'll make a
Marked, I have only marked which portions you have. Please give me those copies. That will be
very well.
Mr. Shah, you have referred to 2023 SCC online Allahabad. You have referred.
Yes.
It out.
Grateful.
When?
Next Tuesday. Next Tuesday.
Next week, which day?
Tuesday, my lord.
Mr. Shah, next Tuesday. Interim order has expired.
My lord, interim order has expired long back. My lord, your lordship correctly pointed out it cannot be extended because appeal is not in existence. But my lord, I don't think I can, my lord, make that prayer before your lordship because, my lord, I am arguing, my lord, that appeal is not in existence.
So I'm keeping it under the same heading. How much time it will take? Or I can fix in later part of the day.
Yes, yes.
I think that will be better.
Whenever your lordship.
Yes,
next Tuesday, 4 p.m.
Yes, ma'am.
Mr. Shah, learned senior advocate. Coming after 5 minutes.
Grateful to my lords for the patient here.
Wait, my lord, it is the case of 2024. My lord, why I am before my lord seeking expeditious disposal, my lord. The parties are not living together since 2017. 2021, I filed the earlier mat suit. The wife convinced me that let's come to an amicable settlement. So I let the earlier matter be dismissed for default. Thereafter, she did not let the amicable settlement effectuate. My lord. Now that I have filed this matter, now, my lord, I have filed this matter. She came and took out one maintainability petition that has also been rejected, my lord. That is why I am seeking an expeditious disposal, my lord. Kindly consider the order dated 2nd of April 2025. It was her proposal that in the year 2023 that let's settle the dispute. My earlier suit was dismissed for default by me. That is admitted by me, my lord. Now back then she did not withdraw her cases which she had filed. I have also mentioned those cases, my lord, in this petition. But thereafter, when the amicable settlement did not work out, she took out this maintainability petition and rejected.
Is fixed for reconciliation on 17th of July.
July, my lord. This suit is proceeding now. My lord, one innocuous request upon the learned trial judge.
Application under Article 227 of the Constitution of
I am for the petitioner lordship expeditious disposal of a suit application for alimony pendent delight filed by the wife and a suit filed by the husband. I filed an application in the year 2023, July 2023 till date. My lord, is pending. Husband is imposed.
Have you filed your affidavit of acceptance?
Yes, yes, lordship. Kindly come to order dated.
This application under Article 227.
for the plaintiff opposite party, Your Lordship.
Yes, Mr. Rai.
7.2 is rejected along with section 7.3. Allowed.
On what ground?
7.1 not been complied with.
7.1 not been complied with.
There is a direction that I have to, according to them, I have to deposit the rent to the landlord or the court after receiving the notice under section.
Mr. Rai, give me 2-3 dates when summons was served.
Summons was served on that is within 1 month. There is no dispute about the service regarding the month.
Please give me the dates, Mr. Rai.
Date.
Nowadays, you have to give the list of dates in the civil division applications also.
It was filed on 2nd
So
December
relevant dates are
2016.
not here.
When he received ballot, that was not there.
Admitted areas of rent have you deposited?
According to me, there is no admitted area of rents. There is no admitted area of rents.
Show me your 7.2 application.
Yes. Kindly consider this application. Paragraph 7. The 7.2 application.
They haven't annexed the application.
What is page 14?
No, that is wrongly. That is their objection. That is wrongly been annexed. This is a copy.
That is their objection.
Yes, it has wrongly been annexed as copy.
Please see my page 14.
Yes, জজ সাহেবটা ঠিক আছে তো জজ সাহেবটা ঠিক আছে
So you are giving one copy to the court and another copy to the
my copy also there is objection. The 7.2 is not there.
Yes. Which paragraph?
7.
Paragraph 7.
Paragraph 7. Mr. Rai, please come to paragraph 3.
Thereafter, the defendant paid rent to the December 2015. My lord is looking that portion, last portion.
Yes, yes.
February, and when the defendant asked for receipt of the 6 months, we averted to grant receipt on the plea non-availability of the rent book. Grant the same. The defendant have also sent a letter on such and such seeking those receipts. Thereafter, the defendant sent rent for the month of March 2016 by money order, but the same was refused and returned to them.
Yes. So March you have sent by money order. It was refused, returned. Did you deposit the amount of rent for the month of March 2016? Where did you deposit?
So, but whether this, my lord, this was taken into consideration. 7.1 application was filed. 7.1
for March, you have sent, returned.
Refused.
Refused, returned. What did you do with that?
That is why, my lord, the 7.1 application was filed. So far me is concerned, my lord, can you consider paragraph 5? Can you consider?
Sir, what is the dispute in 7.2?
7.2 is the area.
Period.
Period.
Not the quantum.
Quantum is not the dispute.
So, according to you, your own case in paragraph 3 is till February you are not a defaulter. That is your specific case. Till February 2016 you are not a defaulter. You are not a defaulter. Now, March you have said returned, refused. So, what was your obligation to do?
That is why the 7.1 application was filed.
When the suit was filed?
Yes. December.
Yes. So, suit was filed in December. When this, that is why I asked you the dates. When the summons was served?
She did do that. The defendant of due compliance started depositing rent from April 2016 and onwards with the rent controller.
No difficulty on that. So, in April, Mr. Rai, in April you have deposited before the rent controller.
Yes, March, can you consider?
So, why? What happened with March?
Now, when it was returned, from April onwards I can deposit. Within 15 days of the next.
March you have sent, refused, returned. April, again you have tendered, refused, returned. April deposited. What did you do with March? Subsequent month you have deposited. Previous month, what did you do with that? It's not 7-1 deposit April. April is also before the rent controller.
Yes, because
Yes.
received notice after the same.
No dispute on that. What did you do with March? This was admitted default, arrears according to you. Admitted arrears according to you.
So the area minor can consider whether the refused, what refused, even take it aside.
It's not an admitted arrears. Mr. Rai, if you have tendered refusal, so are you not required to deposit anywhere?
Yes.
Either before the rent controller.
That is why for April I am depositing.
7-2 April you are deposited. March.
That is the month of April or from the April, minor can consider.
March, Mr. Rai, when did you file this application under section 7-2?
7-2, minor can.
Everything is blank, Mr. Rai. No date anywhere.
Huh? It's 3/2017. It's 3/2017.
6/3/2017.
An objection.
March, Mr. Rai, either you have to have you have not deposited before the rent controller, so you are required to deposit along with 7-2.
That is why minor can consider 70 application file, and that was rejected only on the ground that your lordship can consider the order impugned. That is why minor now minor can consider the order impugned.
March, were you required to or not required to deposit?
I have to deposit March. I have to deposit.
Did you deposit along with the application under section 7-2?
Only that was not from April onwards. Then minor, if your lordship can consider it that way also, whether I am entitled 7-1 application was filed. 7-1 application was filed.
Mr. Rai, 7-1 appears when there is no dispute situation. Here you are disputing. When dispute arises, 7-1 is nowhere. 7-2, you are required to deposit the admitted areas. That is why the admitted areas. No dispute, you have to deposit the entire amount.
No, Malad, 7-2, Malad, I am conscious about Malakali consider section 7-2 comes along with section 7 and upon deposit of section 7-1, I can invoke 7-2.
7-1 is when there is no dispute. You have raised the dispute.
Regarding Malad, the area.
Yes. Anything that is a dispute. Mr. Raj, 7-1 is no dispute situation. You are not disputing the rate. You are not disputing the period. Yes. Sir, why are you getting agitated? Cool down, cool down.
Or a suit being instituted, Malakali consider I am not agitated.
Don't get agitated. Yes.
Or a suit being instituted by the landlord for eviction on any of the grounds referred to section 6, the tenant shall, subject to provision of subsection 2 of this section, pay to the landlord or deposit to the civil judge all arrears of rent calculated at the rate which is last paid.
Yes.
It was made within 1 month from the date of service of summons on the tenant or where he appears the suit without summons. These are the things.
Yes.
Now, Malakali considers 7-2.
Yes.
If any suit referred in subsection 1.
If in any suit referred to in section 1 means suit under section 6.
Any suit referred in subsection 1.
Yes.
There is any dispute to the amount of the rent payable by the tenant.
Yes.
The tenant shall within the time specified in that subsection. Malakali consider.
Here you are raising a dispute with regard to the period of default.
This subsection is 7-1.
What subsection is 7-1?
My lord is saying these two in subsection 1. It postulates 7-1, not section 6-1.
first part of section 7.2 says, if in any suit referred to in subsection 1.
Yes, subsection 1 the suit.
Suit is suit under section 6.
Subject to
That-
question, my lord, 1 year lordship kindly.
That is suit under section 6. Yes. So this first part only is a suit. Instead of mentioning is again it has said in a suit mentioned under so it is a suit under section 6. There is no difficulty. So in a suit under section 6, there is any dispute as to the amount of rent payable. Here you have raised the dispute. According to you, you are not a defaulter up till February. March, according to you, you have tendered, he has refused. April, you have again tendered, refused, you have deposited. So March, there is an admitted arrears according to your own showing. You have not deposited. You are required to deposit this amount.
That I have. That application is paid. I have also paid.
Have you deposited March along with 7.2?
7.2, that is 7.2.
Then admitted amount, it's admitted, Mr. I, it's an admitted default. Admitted default, not deposited.
Well, my lord is looking in some other way, my lord. If I have filed an application.
The way the statute has laid down, not in any other way, Mr. I.
সেটা আইনটা নয় the amount admitted.
It's well settled. The admitted, in your case, let us delete other months. March, admitted arrears is there. You are required to deposit the admitted arrears along with 7. March, you have not deposited anywhere, neither before the rent controller nor along with the application. So, right, what is the reasoning given by the learned trial judge? Let me now see the reasoning.
Now I'll consider in another way. Whether this 7.2, whether I'm entitled to get that extension or not.
No. First, initially admitted amount, you have to deposit first.
Then admitted counts within 7.1?
No, admitted amount does not come within 7.1. It's admitted areas by you.
Yes.
7.1 says all areas of rent.
Yes.
When you are disputing, it's admitted areas by you. Because according to the plaintiff, you are a defaulter for long period.
So the plaintiff is concerned. My case is that.
So now, for 7.2, you may require an adjudication whether you are defaulter with regard to the rest part or not. So you are not required to deposit with regard to the rest part. But March, you have admitted in your own application to be a defaulter, you have to deposit that.
That I have to deposit, but consider.
Have you deposited, Mr. Rai? If you have not deposited, because the statute says along with an application. If
that 70 application was not considered on that, then Malakali consider. That is why Malak Predeposit I want. Whether this extension applies to 7.1 only. Today, if I file an application, say that allow me to deposit the arrear. Whether this extension comes with the purview of 7.1, because it is 7.2, the extension has been granted within 1 month or 2 months, the time period for the purpose of filing of that application. Whether it also be applied to 7.1 also.
It's not 7.1, Mr. Rai, it's 7.2.
7, that is what?
7.2, your case is not that you have applied after the period. You have applied within time, but not along with the admitted arrears.
Therefore, Kali considered, today my application is not in form. Kali consider in that way also.
Yes.
Not in form. Whether, my lord, that not in form, not entitle me to file an application under 7.1 for deposit of the admitted arrear rates.
No, I could not follow you.
Today I filed an application under section 7.2 saying that according to me, there is no default.
Yes.
Please adjudicate the default.
You cannot do that because you are admitted, Mr. Rai.
According to, by
you cannot take another stand that you have not, there is no default.
According to me, my lord, so I have tendered, refused, whether it can come.
Your own showing. This application under Article 227. Yes, on the next matter.
9, Your Lordship. I was praying for a week's time, Your Lordship. The certified copy has not yet been given, Your Lordship.
What is this matter?
Your Lordship, I filed an application under 151 seeking correction of an order number 7, wherein there has
Order
been
number?
7, page 24 of the petition, Your Lordship.
Yes.
My Lord, I am a third party who had filed an application under Order 21, Rule 97, Your Lordship.
Yes.
However, in this order, the petitioner, Shri Pradeep Kumar Pal, he is the decree holder, Your Lordship. His name has been recorded as the petitioner of the application under Order 21, Rule 97. I prayed for correction of this order, the name be deleted and my name be incorporated. I prayed for correction of this order, Your Lordship, by 151 application, which is at page 29. That has been turned down.
What is your miss case? 21 of 2023.
21 of 2023.
So, has notice been issued on this and directing this miss case to be disposed of? Yes.
My application be disposed of.
Yes.
But my Lord, kindly sees one thing, Your Lordship. On Your Lordship, only my name was to be corrected, Your Lordship.
That will inure to your benefit at a subsequent stage. Some confusion arises. That
My
will
Lord,
inure to your benefit.
My Lord, my case was
confusions
that in
remain.
spite of there being an injunction order, the landlord, this is a second
All
suit.
confusions will inure to the benefit of the third party in a proceeding under Order 21 to 97.
Your Lordship, until and unless this name is corrected, Your Lordship, that my Lord listens to me for once, Your Lordship. This is a second suit. The first suit was filed by me against my landlord, Your Lordship.
Your miss case, you are concerned with the disposal of a miss case. You must be anxious of adjudicating your rights, title, and interest.
My Lord.
I'm expediting that.
My Lord, the name, my Lord make corrections to that effect, Your Lordship.
Yes, yes. I'm protecting your interest. The grievance of the petitioner Please call the next matter.
Lordship, I am for the petitioner. The plaintiff is the petitioner before your Lordship. Lordship, there was a caveat I served, Lordship. Mr. Ujjwal Trivedi. Lordship, by the order impugned, Lordship, amendment of written statement has been allowed.
Where is he? Can you ask your junior to call him?
What is he? Then Lordship, kindly.
All right. You have mentioned the correct date of appearance. Yes.
Yes, yes.
10th of June. Yes.
Lordship, by the order impugned, Lordship, an application for amendment of the written statement has been allowed. Challenging that, Lordship, I have come up before your Lordship. Now, Lordship, I filed a suit for eviction against one Bhutnath, Lordship, in respect of one shop room number 1. Now, Lordship, he appeared, filed his written statement and admitted that he is a tenant in respect of that property. Thereafter, Lordship, during the pendency of the suit, he died. And his legal heirs were, Lordship, substituted. They adopted, Lordship, the written statement of their father. Now, Lordship, by filing an amendment application, they want to say that they are not a tenant in respect of room number 1. Actually, the father is a tenant in respect of room number 2, and actually the son, one of the defendants now, he is a tenant under under me, Lordship. Challenging that, Lordship, I have come up before your Lordship. Lordship will kindly see the original written statement, Lordship. It starts at page 26.
You filed a suit against the father.
Father.
Now, after the date of the father, the heirs were brought in.
And they adopted the written statement.
Yes. After that, their new stand is that the father was not the tenant in respect of this shop room. They
Yes.
were original tenants in respect of this shop.
One of the sons, one of the defendants.
Yes, next.
My lord, I appeal for the petitioner, my lord. My lord,
Yes.
this is my application seeking expeditious disposal
Of what?
of an Order 7 Rule 11 application that I had filed in April 2016 and has been pending.
Otherwise, ready for hearing.
Yes, my lord. My lord, may I just in very short give my lord the background, my lord. My lord, the original plaintiff and the original defendant number 1 are brothers. In 1980, the plaintiff executed a general power of attorney in favor of the original defendant number 1. The same power of attorney was registered also in 1980. This suit has been filed in 2016 seeking cancellation of the said power of attorney, my lord. My lord, I have entered into appearance. I have filed my written statement.
Application under Article. Disposed of. You disposed of.
Item number 12, Mr. Kushal Chatterjee is appearing for the petitioner. I'm praying for a short passover, my lord.
He was here.
Yes, he was here, my lord. He is engaged in courtroom number 8. A matter is going on, my lord.
You are here.
No, my lord, I am not the advocate on record. The advocate on record is appearing virtually.
On the prayer of the learned advocate for the
short.
Madam, for the petitioner.
Yes.
The petitioner, if you look at the husband, he challenged the order passed under section 24 of the Hindu Marriage Act. It was alimony pending like.
Why you don't want to pay alimony to the wife, Mr. Ghosh?
But I want to pay.
Pay.
But the wife is working. She used to earn. But if you look at kindly see,
husband say wife for
I am, but the kindly see.
But fails to prove the earning of the wife.
I want to show that.
That is the only difficulty.
Just 2 pages. But nothing more. Kindly see just 2 pages. But firstly, kindly come to the impugned order, the second page. Impugned order, second page, kindly see third paragraph, 1 to 4th paragraph. At the time of hearing, learned lawyer for the petitioner would fairly submit. The OP has been maintaining the educational and other expenses of the minor daughter. But I'm maintaining.
That is the impugned order. You have annexed the certified copy of the evidence and other things.
The impugned order is from
First, we annex the certified copy of the entire evidence.
Certified entire copy has been taken from the trial court. That's why I have to annex. I cannot detach the documents.
Yes. Which page of the impugned order?
First, kindly come to the second page.
Yes.
4th paragraph starts with at the time of hearing. learned lawyer for the petitioner fairly submit. OP has been maintaining the education and other expenses of the minor daughter. Number I am maintaining my minor daughter. Number kindly
It is
come.
your obligation, Mr. Ghosh.
I'm maintaining. I'm saying that I'm maintaining. This is not, there is no such. Number kindly come to the first, second, fourth page. That is the paragraph, first, second, third, fourth, fifth paragraph, starting with, while considering the affidavit of asset and liability of the petitioner, and OP it is suffice that OP is employed in Sima Surakha Bal, Jawan under Government of India. His monthly salary is rupees 55,000. Approx per month. He father is not kindly skip over.
That is you.
That is me.
Yes.
Exhibit A and B are TDS certificate whereform it's seen that the petitioner has some bank account, but she is not an income tax payee. On evaluation of oral and documentary evidence, which find support from the respective affidavit of asset and liability filed by the petitioner and the OP to prove their claim, it comes to find that the petitioner is lazy without independent source of income. Now, if your lordship kindly see the affidavit of asset, in the affidavit of assets, it did not disclose his bank account, her bank account. I produced the TDS certificate showing that she has bank account and she is getting interest. That's why if you lordship the TDS certificates are annexed to my revisional application. The Ranet Talco not even considered what are his income, what is the money lying in his bank account, in her bank account, and not fixed 12,000 per month without considering anything. I have to pay maintenance to my wife. There is no such. I cannot run away. I have to pay. But Lana Telco did not consider anything. Simply said, I.
Where is the affidavit of assets and liabilities?
Yes, my lord. Kindly come, the affidavit of asset of the wife. It's a type copy, page 25.
Yes.
My lord, now, my lord, kindly come, page 28.
28.
28. 28, serial 8. Income from other sources, interest share, dividend, LIC fixed deposit attached with the affidavit, and nothing has been attached. Furnish copies of bank statement of all accounts for the last 3 years, not applicable. She has not even also disclosed the bank, her bank accounts.
Where are the TDS certificates?
That is in the certified copy. If you that is in the certified copy as well as also annexed with the document.
Just show me the TDS.
Certified copy, last 2 pages. Two pages. These are of 2017-18 and 18-19.
Yes.
And now, my lord, kindly see the TDS certificate of the wife for the year my lord, 2022-23 and 22-24.
Where is that?
The page 41-42. Kindly see, she earned interest 91,132. Page 41, my lord. But right hand side, first amount 1.522, 51, 91,132. She earned interest in 2022-23 financial
Where
year.
do you get that? 91.
No, kindly see, my lord, this right hand side. The column starts information code, information description, information source, count, then amount. Got it?
Amount is 6393.
Amount,
amount is 6393.
6393.
Yes. Where do you get 99?
Can you see my lordship?
Oh, 19,350.
19,350, then 38,482, 33,000. These are the interest she earned from the fixed deposits. in Postmaster General. Thereafter, the next page for the financial year 2021-22. She earned interest 5,288. Nothing has been considered. Before that, page 44, financial year 2021. This has not been disclosed before the learned trial court.
After all, you have a daughter also, you have to pay for the daughter also.
No, I'm paying my daughter.
That
There
is
is
the
no
educational
dispute.
expenses.
No. My daughter is residing with me. My daughter is residing with me.
Praying for not today, Lordship. And for the petitioner. Lordship, he is in courtroom number 19.
Who is appearing?
Lordship, Learned Advocate Gautam Banerjee. Gautam Banerjee.
The prayer of the learned advocate for the
Your Lordship, Mr. Mahato has missed his brief today, Your Lordship. Kindly tomorrow, Your Lordship.
on the prayer of the learned advocate for the petition. Yes, call the next matter.
Lord, I appear for the petitioner.
Yes.
Lord, the State Consumer Dispute Redressal Forum and the National Consumer Dispute Redressal Forum has dismissed my appeal, Lord, since there was 257 days of delay.
I've instructed that I have not.
I still, sir, but only one thing, he should not
There's
proceed
nothing
with
in
the
this matter,
execution.
Mr. Chandra.
Nothing. I just tell you,
Who says
no, I told them, why have you annexed all these documents?
this shows
Lord,
there is nothing in it.
2003 agreement for sale. 2005, he says in his petition, I have refused to execute. 2016, he went to the consumer forum. 24 consider that. I lost my husband, I could not contest the proceeding. There was a delay of 257 days that has not been condoned by the state forum and national forum. 257 days only. An octogenarian lady.
Length is not material, Mr.
Yes, if it is a meritorious matter, your lordship will consider the delay. And if there are materials, the court says there are materials.
Sufficiency of cause.
Yes. The court says these are the medical records. All these papers are medical records. Court says the doctors have never prescribed me to be on complete bed rest, so I have no record. That's the only ground. National Commission did not even touch. State Forum says this is the ground. 257 days delay has not been condoned. And the date of refusal is 2005. 2016, he approached the court. It was the duty of the district forum to look into it. It's completely barred. 24 cases, 2 years, within 2 years of the refusal, you have to come. Paragraph 9 of the petition before the district forum, he says, I have by writing a letter in November 2005 refused him. But only one thing, Lord, Mr. Mukha, I have one apprehension, Lord. On the returnable date, if it goes down, they are proceeding with the execution. I will give him a copy right now. I don't mind not giving. I am giving him mine copy, Lord. Because in any ways, পড়ে না তুই পড়ে আমায় দিস আমার তো আমি তো পড়া
matter is
$70 for the petition.
Yes.
There is a suit for declaration filed by the wife. My lord, I have challenged the order of ad interim injunction passed in the misappeal, my lord. But kindly come to the prayer of the injunction in page number 46. Kindly see the prayer.
Page 46.
46, my lord. The prayer of the temporary application for temporary injunction. For an order of temporary injunction restraining the defendant, that my client is the defendant petitioner here, from dispossessing, ousting the plaintiff and her 2 children from the suit premises, and or from disturbing peaceful possession of the plaintiff and her 2 children in respect of the suit property in any part from the transferring, selling, alienating schedule of the property. But the plaintiff here is a wife and he is not the owner of the property. The defendant petitioner is the owner of the property and he purchased the property by mortgaging that property in a bank. Bank is not made party. The ad interim order of injunction is page number 49. Kindly see the page number 49, passed on 16th September 2021. First, second, third paragraph. The case of the plaintiff is that the defendant is the husband of the plaintiff. The defendant is the owner of the A scheduled property, which is a self-contained flat where the plaintiff has been residing since the marriage. Since marriage, flat was purchased after 3 years of the marriage. Currently, the plaintiff has been residing there with her minor children. Relation
but the
of
defendant.
Defendant is the petitioner here.
Yes,
He's
you
the
are
husband.
defendant.
I am the defendant.
Yes.
The petitioner left the matrimonial house. There are several affidavits I am indicating before your lordship. Kindly come to page number 121. One by one I am coming. Page number 121.
So what happened after this?
My lord, this injunction was affirmed in the appeal, my lord, in the misappeal filed by my client. But the appeal, misappeal, that is in page number 55, my lord, your lordship kindly. 55, my lord.
That is a certified copy.
Yes, certified copy is there. Certified copy is there. There is a pagination here.
Yes, you serve a copy.
Page number.
Cannot be stayed, Mr. Day.
But in the meantime, my lord,
What? Stay. Can it be done? Injunction order, contested injunction, stay at the
then
admission
I'll come.
stage.
I'll submit.
The
My lord, for the caretaker.
Nobody for the petitioner. They're afraid of you. Why they are not appearing?
Perhaps the merit of the case, not like
Pass over. Next.
But I'm for the petition.
So Chatterjee, don't scratch your head.
যে কথা আছে পড়ে যাবে the plaintiff the plaintiff is the petitioner before your lordship. The suit case, the plain case is that the A schedule property I am the owner. B schedule common P schedule passage, not common. B schedule passage is a part of A schedule.
You are the defendant.
I am the plaintiff petitioner before your lordship. The plain case is that the A schedule property owned by me, B schedule passage is a part of A schedule passage. The club schedule property, A schedule property. The club is disturbing the defendant. The club is disturbing in respect to the B schedule property, which is not my own property. There, the club, being the defendant, filed the written statement, say, no, in your deed, there is no mentioning of that passage. That disputed passage is belong to someone else, and the club is permissive possession over the same. In that suit, I got an ad interim protection. They filed one modification application.
That suit?
In this suit.
Yes.
Only one. In this suit,
You said that suit.
No,
I was thinking of some other.
No, because they have filed also one counter claim. They have filed one counter claim.
In this suit, you have obtained an order of injunction.
Injunction, they filed one modification application asking permission so that they can conduct the Durga Puja festival over there. While considering that application for modification, the court categorically found that yes, in the deed, in my deed, there is a sketch map where is mentioning of that passage, which is part of the B schedule, A schedule property. And the puja which has been
the impugned order?
I'm coming. The puja which has been conducted by them in a separate holding altogether. The permission and all those documents shows that. So this is non-suit property, wherever the Durga Puja has been. So by that observation permitted them to use that passage for the purpose of that year, and thereafter dispose it of that modification application. Thereafter, they have taken out an application for local inspection. Kindly now takes up the schedule of the local inspection. The
local inspection allowed?
Yes. The conspectus of this suit, I have given your lordship the narration. Kindly takes up the schedule at page 60. Page 56, it starts.
Yes.
The 4 points is being mentioned. Page 60. Kindly similar the point number 3 also.
Where is your plaint?
Yes, my lord. Kindly takes up my plaint at page 15 of my lord's brief.
(21) is your sketch map.
21, yes, my lord.
Schedule B is outside Schedule A.
No, my lord, it's a part of A schedule property, entirety.
Sketch map does not say so. Sketch map does not say so.
My entry is from this. My lord, my title deed.
Mr. Mr. Mukherjee, this is not the way of a sketch map.
That, my lord, has been depicted, my lord, in such a way, my lord.
But it's your plain.
But it's not been disputed by them also. Kindly takes up, bolte. My lord, kindly takes up page 20.
And you have said common passage.
Yes.
Not your own property.
No, it's, my lord, my vendor in the two deeds, they have given this, my lord, along, my lord, A schedule property along with the right of this B.
Give me a minute.
So, my lord, this is something which needs.
Give me a minute.
Smile. Bol.
Yes.
Lord, I will take your lordship immediately. What is their immediate reaction in respect of this pleading? Kindly takes up page 31, Lord, page 22. The written statement come counterclaim starts. Kindly takes up page 31, paragraph 19 of the written statement come counterclaim.
Mr. Mukherjee did not go to the counterclaim.
No.
What is the prayer in the plaint? Your prayer in the plaint.
A decree of declaration that the plaintiff has right to use the B schedule common passage for the free ingress and egress of the A schedule.
Please proceed slowly.
Yes, my lord.
Has legal right for user of the B schedule common passage,
my lord,
for free ingress and egress to A schedule property through the B schedule common passage. So it's a common passage. For that purpose, you have only a right of user to go to your A schedule passage.
Absolutely.
So B is not part of A.
I absolutely.
B is not part of A as per your own plaint.
But even it's my case, I have to prove that it's my plaint.
Your plaint does not say its part. Your plaint does not say its part. That is why I am trying to point out to you.
Very good. Not kindly proceed not according to my own plaint case.
You have to proceed according to
yes,
your
yes,
own
yes,
plaint.
yes.
You cannot go beyond that.
And what is their written statement case? Once looks at page paragraph 19 at page 31. So
now
both
this local inspection is in aid of injunction.
Yes.
Where is the application? Where is the order of injunction?
The order of injunction, initial order. Yes, yes. In the bunch of certified copy, it has been there. Kindly takes up order number. Order number 1. এটা কি পেজিনেশন করেছেন? Page 36.
Yes.
Kindly see paragraph 19 once in their written statement at page 31.
31.
Yes. So I will have to adduce my evidence to prove that I have a right to use the B. May not be part of A, as per
yes, right of user.
Yes. That is my
yes.
case, I will have to prove that. What is their case? They have not disputed the identity around that. Kindly takes up paragraph 19. May I place before your lordship that the defendant submit that the aforesaid disputed plot of land, that B, which is actually owned and possessed by Shri Anil Kumar Bhattacharya and other co-sharer, and they afforded permission written to the defendant club to celebrate Durga Puja and the other functions.
He is also your co-sharer.
No. They are saying that Anil and other co-sharer of that plot, they have given a written permission to them to hold Durga Puja and use that. So they will that is be disputed. So they will have to prove that. Kindly now takes up once the observation of the learned trial judge, page 54, while deciding the application for modification.
So, Mr. Mukherjee, please come to 34, page 34.
Very good.
Is schedule X identical with schedule B of your plaint?
No. They have given, they have kindly see, very consciously, very cunningly, they have given the plot numbers. Your lordship knows, at Howrah, there are plot numbers as well as holding number.
I do not know. You are the best person.
No, there are. So they have given, consciously they have not mentioned. That's why I am inviting before your lordship at page 54, the observation of the learned trial judge. 54, it starts, while deciding their application for modification. Kindly takes up page 55, second paragraph, once.
Are those observations binding?
No, I am not saying, Look,
Now,
prima facie, what is there? The court himself observed that whatever where they are celebrating puja is non-suit property or different
now,
property.
Mr. Mukherjee, please come to the application under Order 39 Rule 7.
Yes, my lord.
So,
In earlier occasion, they have filed, my lord. But
sir, please,
subsequently
please,
withdrawn. Later on, we have filed this application.
please wait, let him exhaust himself.
Look, page 60, the schedule.
Yes.
Look, the draw rough sketch map of the suit property situated at now kindly tallies from their own schedule of Schedule X. Nowhere they have mentioned the my lord holding number.
This is my property.
This is my property 559.
Schedule
Schedule A.
No. They have not mentioned Schedule X. They are on your own.
Yes. That's why, my lord, I am on.
They are, yes. They are on your plain schedule.
Yes.
So, eastern side field of the A schedule property, including structures standing thereon, to note the very existence of the purported common structure in between, common passage in between Schedule A
Whether,
and
my lord,
the ground field. What is the ground field? As purported deemed in Schedule B.
Pausing here for a moment, kindly tallies it with paragraph 19 of their written statement. Is it their case that there is no existence of that? They have stated that it is a disputed passage, belongs to someone else who has given them written permission. So what is the necessity for exercising this entire exercise by the learned trial judge? It's clearly, my lord, fishing out evidence. This is something which both the parties needs to be proved by way of documentary evidence.
No. What is meant by point number 3? Very existence of the purported common passage
in between Schedule A
and
the said ground.
Where is the field? Where is the
kindly comes back, my lord, their written statement does not disclose about my lord, something, my lord, once in a blue moon they have taken out an application, though contrary pleadings is being made in their written statement.
What is the finding of the learned trial?
Yes, kindly now takes up, my lord, the order impugned. Third paragraph, not on perusal of on careful perusal, it is found that the defendant here in the instant suit has filed the counterclaim where he claimed to be the lawful permissive possession of the suit property. The defendant in the instant petition states that in order to protect as well as preserve the suit property in its original condition, immediately a local inspection is required by the plaintiff. Is very politically influenced person. If there is such a scenario that the plaintiff is trying to demolish the said structure lying at the suit property, this court is of the opinion that the instant petition is required to be allowed. Lord, kindly consider, Lord, exactly not the contrary case what has been made out in the written statement. Question of protecting construction beyond the pleading in an interlocutory application, not in aid of the pleadings of the original written statement.
Where is the order of injunction?
Yes, my lord, kindly takes up, my lord, the order of ad interim injunction, order number 1, my lord, the bunch of, my lord, the
certified copy.
Yes. The first order number 1 dated 28th of August 2024. There is no challenge to this. On the contrary, they have asked for permission so that they can celebrate Durga Puja in respect to that portion.
After this, where is the order of modification?
Yes, my lord, kindly takes up the modification order that I have annexed, my lord. My lord, page 50.
20th of September.
20th of September.
All right.
Just prior to penultimate paragraph, if your lordship takes up the paragraph starting with on perusal of document on record.
All right, come at 2 p.m.
My
Pass over matter.
Miller, pass over matter item number 12. এই কখন
Yes.
So, my lord, I have shown before your lordship the plaint case, the case made out in the written statement come counterclaim, the ad interim order which I am still now enjoying. There is no challenge to that. On the contrary, in the modification application, Lord, while deciding that what is the prima facie observation of the court. So, my lord, in my respectful submission, my lord, based on this pleading, the interlocutory application which they have filed under Order 39 Rule 7 is not tenable. Firstly, secondly, this entire exercise need not to be gone into, my lord, for the purpose of deciding the suit even. It's my suit, primary burden is on me to prove my case. And I was showing before your lordship the impugned order. And the first paragraph itself, my lord, if your lordship once looks at, the submission is being made that the learned advocate for the defendant submits that the plaintiff is trying to oust the defendant from his peaceful.
Where are you pleading?
My lord, the impugned order, my lord, order number 15, dated 6th of May 2025.
Yes.
Learned advocate for the defendant, has your lordship got it?
Yes.
Submits that the plaintiff is trying to oust the defendant from his peaceful possession in the said suit property. Kindly marks, my lord, now what is the property? 659. 659 is the Schedule A property.
Yes.
And also trying to demolish the said structure thereon. Further states that in order to protect as well as for preservation of the suit property, immediately a local inspection commission is required to be held. Thus, pray for appointment of the advocate commissioner to inspect the suit property as per schedule of the application. So it is the case in the local inspection application that I am rather trying to oust him in respect of the A schedule property. Paragraph 19, Lord, may I just remind your lordship of the written statement, positive case, the existence of the pathway has not been denied. He said, else, Lord, someone else is the, Lord, the actual owner, co-sharers, they are co-sharers and the owners have given them a permissive written possession, written Lord, permission for occupying the property. But not touching to the A schedule. That is the disputed plot as per them, which is B.
Yes, anything more? Yes. Yes, sir.
Lordship, can you come to page 16 of the plain?
Page
16.
16. Please use the microphone.
16.
Yes.
There is a common passage that is B schedule mentioned property on the eastern side of the A schedule property of this plaintiff, and the plaintiff used to enter into the A schedule property through B schedule common passage. This plaintiff hereby annexed the actual topography B schedule atho, which may be treated as part of this plaint, that the dependent club is a very influential club in the locality, and they have close nexus with the local antisocial, the dependent with malified motive and their associates, local antisocial on and from 25th August 2024 came in front of the A schedule property and illegally demanded a portion of the land of A schedule property from the plaintiff from club room purpose, but the plaintiff is not agreed with such illegal proposal of the defendant, and as a result, the defendant became furious and threatened this plaintiff with dire consequence and murder, and also interfered with the plaintiff's peaceful possession and enjoyment over the A schedule property, and also obstructed free ingress and egress of this plaintiff to the A schedule property through the B schedule common passage, illegally taking law in their own hands. My lord, we are not concerned with the A schedule property. Our club is situated on the B schedule property, my lord, common passage, my lord. আর আরেকটা জায়গায় কোথায় ওখানে প্লেনটি বলা আছে যে ওরা দুজন দেয়ার ওয়াজ এ co-sharer, my lord. Two co-sharers are there, my lord. They have purchased the property from one side, and we are enjoying this property from the time immemorial from the other co-sharers, my lord. Paragraph 3 of the revisional application, my lord. Page 6. And in their deed, my lord, there is no mentioning of B schedule property. Deed করিয়েছে তোর কাছে আছে এই তো এখানে বি শিডিউল বলে কিছু লেখাই এই তো এখানে ডেট ডেট ফাইলে বি শিডিউল কোনো প্রপার্টি লেখা আছে ফাইলে শুধু এই শিডিউলটা লেখা আছে এখন বি শিডিউলটা আমরা অ্যাড করছি দলিলের কপিটা deeded copy. Yes, my lord. And in the purchase deed, my lord, there is no mentioning of B schedule property, my lord. Only A schedule property.
What is the necessity for local inspection?
My lord,
Please make your submissions on that.
To my lord, depict the actual position and
what is the actual position according to you?
Actual position,
Which
my
you
lord.
want local inspection?
Whether there is a bhoghar or not, my lord.
Whether there is
bhoghar, my lord.
Where is your pleadings to that effect in the written statement? Come counterclaim. Sir, are you ready with this matter?
Lordship, close on the last day.
It appears that you are holding conference with your junior in court. Then I can give you time to get yourself prepared in this matter.
Paragraph 20 paragraph না না ওটা আমি নিয়ে কি হবে এখন টাইম দেবেন একটা বললাম
Sir, you want time?
Why not paragraph 3 of the commission application
of the commission
order
application.
39 rule 4, my lord. Page 38, my lord.
Page 38, yes. Yes.
That after perusal of the document sent by the plaintiff, it is revealed that the actual matter of fact that the plaintiff purchased a scheduled mentioned property by two separate sale deeds dated 7/5/2004.
Sir, please don't read the entire application. Please show me that portion.
There is no whisper with regard to the, my lord, page 39, my lord.
Yes.
there is no whisper with regard to the aforesaid user of the common passage attached hereto described in Schedule B. It is furthermore appeared that in the plain there is mentioning of alleged Schedule B property, all that piece and parcel of a common passage on the east side of the A schedule property measuring 19 wide running from north to south, situated at premises number 659 Sharat Chatterjee Road, PS Chatterjee Hat District, Howrah 2, but it is totally absent in the four corners of aforesaid two deeds. It is further mentioned herein that in the schedule to the plain, the A schedule property is described in butted and bounded by the boundaries to the east by the common passage, and in the same time B schedule.
Sir, where is the mention of structures in the that property? Please show me that. Please don't read the entire application. If you are not ready, say so. I will give you time. This is at the motion stage.
At a schedule, at a deed. And Lordship kindly take the schedule of the deed one.
All right, keep it.
Nothing on that.
This application under Extreme. Uh, after the thank you.
Documents. Let's documents.
Documents.
Plain text.
Yes, next.
My lord, I am for the opposite party, my lord.
I appeal for the petitioner.
Yes.
Lordship, there had been an order passed by the learned court below directing the Nazir to take possession and execute the decree.
Yes.
That your Lordship had granted stay. I am enjoying.
What happened to that reconstruction?
Lordship, we had filed an application for reconstruction pursuant to our undertaking. Thereafter, we also filed a put-up petition requesting the learned judge to take the matter up and to hear the application. That has not been done. We have been informed that at present, the the local bar has undertaken a resolution not to attend that court, and that court is suffering from a boycott. That has been going on for the last 2 months, your Lordship.
My lord, kindly come to the last page of the impugned audit.
Submitted that you have filed an application.
Reconstruction.
Put up petition, but the trial judge is not taking up that.
If he's not taken up, there's a boycott. I have advised them, please file a section 24 in this court and transfer it to some other court.
My lord, only.
I'm keeping it on next Wednesday.
My
not
lord,
tomorrow. Wednesday week.
Yes, and I've secured the entire sum, my lord. The entire amount plus additional amounts have been secured.
My lord, one indulgence, my lord. What my learned senior friend is submitting, my lord. They have applied for reconstruction after the period has elapsed, my lord.
All right, please come on Wednesday. I will see to it.
Grateful, man.
And everything
Problem has to be solved.
Yes,
but they are not.
All
They are not doing. They are not complying with the order of this High Court, also, my lord.
What is under boycott?
Let me see what I can do.
My lord.
We should come with a solution, not with the problem.
Yes. Yes.
Next week.
Call the next matter.
Grateful. Thank you. Great.
Yes.
The petitioner was a defendant, but number one was ill. And for that reason, my lord, he was filed an application. Kindly have a look to the order dated. Kindly have a look to the order dated 4th September 2024.
Yes.
But the petitioner, your lordship, he was the defendant. He was not ill on that day. My lord, he was serious heart problem, kidney problem. He was admitted. Several medical documents were also submitted. But in spite of that, my lord, the learned court, my lord, rejected the application without giving any adjournment.
From 2017 we start.
17 we are not have any certified copy. They have filed, my lord, the one application for amendment order 6 rule 17. For the Arjun have filed this certified copy. Thereafter, they filed an application for order 39 rule 7.
Which court?
My lord, Shialda. Civil Judge Junior Division, First Court, Shialda.
When is the next date fixed?
My lord, today is the date. Today is the date, but today is the date, but today, my lord, court I have the information that court did not sit today.
So what is the next date fixed?
Next date not yet been given. Up to 2 p.m. court was not there. Court was not in session.
Why?
Hello. Yes, madam.
Who is appearing for the other side?
No, there is no caveat. We have already asked them to appear, but they are not turn up.
I told you yesterday to inform the bank.
My lord,
said you know who is appearing. You inform, bring him. Otherwise, no. Yes, call serially.
my lord, in this, may I submit
No.
one thing?
Please bring the bank by 4 p.m. I will take up. Yesterday, when you mentioned, I asked you. You said yes. I know who he appears.
Yes, I have already called him, but yes.
Bring him.
Yes, my lord.
Before 4:30. Yes. Call the list. Yes. সামনে এগোন পেছনে তাকাবেন Yes. None appears for the petitioner at the time of
I do appear for the petitioner in this matter, defendant petitioner. Now, this revisional application is required to be heard with CO number 3683 of 2024. That is also appearing in my lord's list in the item, the monthly list, combined list, 1118. Let this two be heard together because one, that is a principal revisional application. This is a follow-up order where I prayed for the adjournment on the ground that the revisional application is pending. Kindly stay here and don't proceed. Declined on the ground.
Which order you are challenging in this civil division application?
That my adjournment prayer has been declined. Since I went and...
Which order? Order dated?
That's the last order, my lord. Kindly come to the order dated.
Where is the other civil division application? Which item?
That's item number 1118 of my lord's list.
Any caveat is there?
Yes, there was a caveat. We have served them already.
Who is appearing for the caveat?
Caveat advocate advocate. The advocate party. Let these two revisional applications be taken up together. That will and dispose of together.
Other civil division
The
application.
learned advocate who was easy. Is she the
Yes, what is the challenge in that civil division application?
In that revisional application, I will tell you a little background. Partition suit between the brothers and sisters. We have all inherited from our father. 2/5 share of the sons and the 1/5 share of the daughter. 2 brothers, 1 daughter. I filed an injunction application, got an order. The plaintiff
What is
filed
the order impugned in that civil division application?
I will tell you, Lordship. What is the order impugned? Plaintiff filed an injunction application, status quo order. Thereafter, the plaintiff filed an application under 151 for police help. I filed an application for under Order 39, Rule 7 for a local inspection. Both application, Order 39, Rule 7 and the police help application under 150 were taken up together. Order 39, Rule 7, my application was allowed and a advocate commissioner was appointed. But in the application filed by the plaintiff for police help, the learned trial court directed me to hand over the keys of a garage and a top terrace to the plaintiff. Challenging that portion of the order, I filed that revisional application. My contention is that at this inception stage, this direction could not have been given. Secondly, that was an application for police help. Either the learned trial court will grant a police help. If the learned court is satisfied, yes, there is a disobedience of order, or will reject it. There cannot be a direction.
So according to you, police could have been directed, you could not have been directed. All right, I'm directing the police.
But there's no case also.
Go there and to break open the padlock.
There's no case also because till the preliminary decree is passed, there cannot...
gave you an opportunity to hand over the keys. So you want the police to go. All right, I will ask the police also to go.
Status quo order is there. There was no specific...
One of the public prosecutor is present in court. I can also direct the assistance of the police.
My Lord, kindly see that order once. What was the status quo order? Status quo as regards to the possession. So who is there in possession? I have said I am in possession of that property. It is not a case that there is a disobedience of order of status quo. From the very inception, I am...
Give me your other civil division application. Do you have the copy? The other civil division application, please show me that.
In 3682. আমাকে একটা কপি দেবেন? বাবা একটাই কপি আনলে আমি আর কি করে বলবো মাই লর্ডকে? আমি তো এটা থেকে পড়েছি। I have one more submission. Although I'm only briefed in this CO 1899, if my lord permits, and
So you do not have any objection if the plaintiff uses the garage and the terrace, because according to your own case, though you have put the padlock, you have provided the keys to the plaintiff.
I am not briefed in that revisional application yet. I am only briefed in CO number 188899, which is appearing today. Once it's clubbed,
The submission, you may not be briefed. You are an officer of the court, please go through that. I am also reading for the first time. Please, you also read for the first time along with me. This is your submission of your learned advocate. So you cannot object to the handing over of the keys. Please come to the second part of the order by which 151 is allowed. The first effective consideration of the court after the line heard the learned advocates for the parties. Please
sides.
come to the last 3-4 lines of that paragraph. The learned advocate for the, I am reading it for you. For the defendant number 1, that is your client, has admitted the fact of padlock at the door of the terrace and the garage at the ground floor, and has stated that the key of the garage has also been provided to the plaintiff, and so no order should be passed as regards the same. So if that is your stand, please open the padlock. A new padlock will be put, keys to be given to both.
To the garage. And
Yes.
regards to the terrace,
First open the garage first. Let me see, proceed step by step.
open আছে আপনি সাবমিশন
Please comply with the order.
গ্যারেজটা ওপেন করবেন তো করে দেবেন আপনার ক্লায়েন্ট কি ইনস্ট্রাকশন
Tomorrow report compliance.
দিয়ে দেবেন তো জাস্ট দেবেন তো ইনস্ট্রাকশন না নিয়ে you will take an instruction.
Not instructions. Please, this is the order.
That's a submission.
Please report compliance tomorrow.
Garage-টা দেবেন তো tomorrow, my lord. Kindly tag both these matters. I will give a notice to the other side. I will take also instruction from my client.
Other side's presence is not required. You have seen.
That submission is there. That submission is.
Cross the first hurdle.
Yes.
Thereafter, the caveator will come.
That's a
Please
submission.
comply with that.
That is a submission. That is recorded.
No, your submission of your advocate.
Absolutely.
He is still representing your client. Or you have taken steps against that advocate.
It is written over here. It's written.
So if there is a wrong recording, your remedy lies elsewhere, not before this court.
Absolutely.
If according to you, the advocate has made a wrong submission, you have to take steps before other forum, not before this forum.
Not absolutely.
So you have not taken any steps.
Not.
So we have to go by the recording in the order itself.
Absolutely.
Please comply with that order.
Kindly keep this matter tomorrow. I will take a specific instruction with regard to the garage and the terrace part that is written. That is only to distance. That's in my fault.
First open the garage.
We will. I will
enter the garage. Thereafter,
we will go
upstairs. Will enter the terrace.
Will
the ground floor, the one has to go upstairs.
Absolutely.
So let the entry to the ground floor first come to the garage. Then we will proceed step by step.
Absolutely. I will take instruction tomorrow.
Absolutely.
And I have one more submission if the parties so.
Sir, first you show your bona fide. After the other side will come. When this matter is taken up,
Pray for not this week, Your Lordship.
as paid for by the learned advocate for the petition. None appears for
Lord, I am appearing for the opposite party.
23.
Yes.
None appears for the petitioner at the time of call. Mr. Moon.
I'm appealing item number
For the petitioner.
Lordship.
Where were you?
Lordship, I was just running from the another court. Extremely sorry.
Yes.
Lordship, in this application, my lord, this application has been filed, my lord. My clerk is coming with the copy, my lord. My lord, this application has been.
We had filed a caveat, but my lord,
Copy has not been
My
filed.
lord,
my lord,
this.
since the CIS copy is wrong number, my lord, mentioned in the CIS copy, that's why otherwise, my lord, same is, I have filed a caveat.
My lord, caveat has been filed and I'm tendering unconditional apology, my lord, that just before the vacation, my lord, this application has been filed, my lord, and we will submit the copy, we will serve the copy, my lord. It is completely, my lord, my mistake, my
What
lord.
is the order under challenge?
My lord, the order against challenge is, my lord, 23rd, my lord. My lord, 23rd, 2025, April, 23rd April 2025, order number 6, my lord. In which, my lord, the learned trial court, my lord, has allowed some documents which, according to the opposite party wife respondent, has been filed, and it is required for proper disposal of the case. For the proper disposal of the case, they have filed, my lord. After the entire written objection, then, my lord, examination, everything completed, and the matter was fixed for judgment, my lord. After that, they have produced several documents, and they made the application, and they wanted to make all those documents as exhibit. Kindly comes to the order, my lord, impugned. My lord, all total 14 documents has been filed, my lord. For
Where is their application?
my lord, that application is not annexed, my lord. But the order was.
This application was filed at what stage?
My lord, the stage was after judgment. The matter was fixed for judgment, my lord. After that,
Mr. Bondol,
After R2B.
how can it be done?
Well, there is
14.
a ample power so far, my lord. My lord, kindly go through 145 evidence act once, 165 evidence, 165.
Are you ready? Do you want
and
I can direct him to give
lordship, lordship.
otherwise because
That is also not
They
reflected in the plaint, my lord.
trying to, each and every time they're trying to delay the matter.
No, 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 my lord.
Kindly fix,
No, my lord.
but tomorrow, kindly fix tomorrow.
given originals to the
My lord, only, my lord, I have filed a Xerox copy. Substitute original copy has been filed. No, my lord, PBS
Where is
finished.
your application?
Yes. Application to the application to yes. Application to the.
No, he has not annexed that along with
lordship.
I have. Okay, application.
All right, you give him a copy.
My lord, kindly direct, my lord. My lord, I will be serving the copy, my lord. I will be serving the copy, my lord.
When?
My lord, kindly counts me 2 days, my lord. I am serving the copy tomorrow. Tomorrow I will be serving them copy, my lord.
For next date. Once
But-
the opportunity has been given to the my lord,
It is very difficult, my lord. It is very.
the PW
No,
one.
for that, my lord,
PW cross examination they taken.
no, my lord, we do not want to cross it, my lord.
Yes.
We are on the basis we are challenging these 14 documents, my lord. Why these 14 documents has exhibiting now?
Original.
Is it required for the corroboration of the case?
Different.
My lord, and that 14 document is also not.
My lord, kindly go through the earlier feast and
My lord, kindly, my lord, that 14 documents is not.
My application for expeditious disposal of an application under Order 9, Rule 13, my lord. My decree, I was enjoying a decree, an ex parte decree. The opposite parties have filed an Order 9, Rule 13 on, this was filed on 12.
Otherwise, ready, you have filed your objection.
Right.
What is the stage of the Order 9 Rule 13 procedure?
Everything is, I have filed my objection, my lord, but in the last 3 orders, my lord, annexed on the time has been allowed again and again.
Application under Article 227 of the Constitution.
My lord, 25, my lord, I appear for the petition.
Yes.
My lord, plaintiff, my lord, in a suit for declaration and injunction. Now, my lord, the learned trial court, my lord, granted me an ad interim order of injunction. Lordship would get that order at page 179. Operative portion is at page 180. Now, my lord, here my case is, my lord, I am the developer. The landowner had granted me, my lord, we entered into an agreement and I started developing the plot of land. Now, my lord, the defendants, my lord, they claim by way of adverse possession. Now, my lord, the defendants, my lord, they started restraining me, my lord, from, my lord, continuing with the development work. Now, my lord, the ad interim order of injunction, page 180, lordship would get, my lord, there was a specific order of injunction. Now, my lord, the defendants appeared in that suit. My lord, they filed their written objection. The learned trial court, my lord, while disposing of the application for temporary injunction, my lord, converted that order into an order of status quo.
Yes.
Now, my lord, kindly comes to page 206 onwards. That is the order passed in the application for temporary injunction. Now, my lord, kindly sees page 208 that both the sides to the instant case are hereby directed to maintain status quo with regard to nature and character. Now, my lord, I was aggrieved by this order because, my lord, I have to continue with the development work, my lord. Status quo would be prejudicial to my interest. But I preferred a misappeal. Lordship would get that order at page 229. My lord,
Yes.
that is the order under challenge, my lord. Ad interim injunction is refused by the learned trial court. In misappeal, kindly comes to page 229.
So order is there. So
Yes.
I can direct the miscellaneous appeal to be disposed of expeditiously. I
Well,
think
kindly gives me my entire development work is stalled because of the order of status quo.
here also I cannot convert this order into a status quo order without hearing the other side. So they
Lordship.
hard. It has to be on a contested hearing, or I can direct the appellate court to dispose of the miscellaneous appeal expeditiously. I think
My
that
lordship, my lord, grants me an opportunity, my lord, to serve the copy, fixes a date in the next week, my lord.
Next week.
Kindly, my lord, because my entire development work is stalled.
All right, all right. The learned,
No, asking copy.
My
My
lord,
lord, my lordship has made the matter returnable, my lord.
yes, contested application. Yes.
Lordship.
I come before your honor to challenging an applications and the order passed by the first Munsif of Howrah District Court. I filed an application against the execution order. And the impugned order, it is
What is the decree for?
Decree, actually, the decree is against the eviction. They prayed for the eviction and eviction order has been passed. The order was executed. And possibly today, they goes for the execution. But what is the part and what is my grievance is that I am not the actual judgment debtor. The petitioner, my name is Buro Mullik, son of Pasuram Mullik. And the original suit was filed by the respondent against one Buro Mullik, son of Banta Dome. And the decree was passed against the Buro Mullik, son of Banta Dome, not against me. In the written statement, In affidavit, I have mentioned that. In the examination of chief, I have mentioned that. In my cross-examination, I disclose my identity. But the respondent neither asked any questions about my identity, and gradually that decree was passed, judgment passed, and then decree was passed and decree put for the execution. This is the one part. I shall not suppress anything. I went for the first appeal, I lose that. I went for the second appeal, I lose that. I went for the SLP, and the order of the SLP is given to the just
page 86.
Page 86.
Yes.
Without going to the merit, it was dismissed. And now I come before your honor that I am not the actual person. From the very beginning, I am telling that.
So you are not affected. If you are not the actual person, so you will not be affected.
That is my prayer.
Possession. You are not in possession.
No, I am in the possession. I property, the question, the
What
property.
is your name? What is your
my name is Budo Mullik, son of Parsuram Mullik. Everywhere I mentioned that. Decree was passed against the Budo Mullik, son of Bantadum. So if the property was executed against the Bantadum, I have no problem. I have no grievance. But you kindly come into the prayer.
That cannot be decided in the civil division application. There is no infirmity in the order. Ashun, this application order.
But my submission, the short submission is that I should not be disposed from that property because the identity should be.
You have to work out your remedies in accordance with law. Look, this application. The stay was granted. So order
stay was not granted at all.
Yes, still the disposal of the special leave petition. Please come to the order dated 27th of February. That is the operating part.
Yes, that was my prayer before the court. That was my prayer.
So now the SLP was dismissed also.
SLP was disposed without any speaking order.
My lord, I am for the respondent, my lord. Opposite party.
Petitioner.
Your Lordship, is it edit 27?
27, yes.
Yes, Your Lordship, I am appearing for the petitioner in this matter, Your Lordship.
Yes.
Your Lordship, this is an MSCT case from which we have preferred the civil revision, Your Lordship. Your Lordship, kindly come to order number 69.
Yes.
Lordship, there are certain latches which is prevalent from the insurance company's lawyer, but Your Lordship will find out that we have been not allowed to file to give an evidence. The DW is not been allowed to be given. Your Lordship, I am praying for the DW to be allowed in this case because we have a good prima facie case in this matter.
What happened on 2nd of April?
Your
It was
Lordship,
fixed for
Actually,
Your Lordship, this has not been done.
was closed on behalf of the claimant.
happened on 2nd of April.
2nd of April.
It was fixed for argument. Arguments is over.
No, Your Lordship, no. We have taken adjournment.
Use evidence.
Your Lordship, at any terms, we are ready for any terms, Your Lordship. But any terms, one day.
What terms you are proposing? Please propose the terms.
No, Your Lordship, I am not there to propose, Your Lordship, whatever falls from Your Lordship, but we should speak.
Don't leave it to the court. That is why I am giving you an opportunity. If you
Your
leave,
Lordship, there is a direction by the lower court to give 100,000 rupees cost. We are ready to pay that 1,000 rupees cost. Your Lordship.
that is why I asked you, because you said to any terms.
No, Your Lordship, we are ready to abide by the lower court order, Your Lordship. We are
There is nothing.
ready.
No. Ready to abide by the lower court's order, you have not done that. So, not now with the lower court's order.
Your Lordship, the advocate has then whatever falls from Your Lordship, my humble prayer before Lordship is we should be given a fair chance to given.
So
30 times they have taken.
All right.
7 years.
You will be compensated with some cost. I'm allowing them to adduce evidence. What is the next date fixed?
Next 11/7.
11/7.
Next date.
So on 11th of July, Mr. Ganguly, you ask your clients to make ready your evidence, witness.
We will, Your Lordship. We will, Your Lordship.
Well, on 7 years, they have taken time.
Shortest possible time, I will direct. And you will be adequately compensated.
They have time, enough
You will be
opportunity.
adequately compensated for the delay. This application under
two claimants, Sujit Ghodai and
আচ্ছা তাহলে না ওইখানে
Ghodai.
একটা we are or 11th of July. Sometime is there. Yes, next. Discuss.
28, my lord, this matter, my lord, the order of injunction, as it is an appellable order. In a partial suit, it is an appellable order.
In a title suit.
Partial suit. So what, my lord, I am praying with your lordship, instead of directing me from correcting the certified copy from the department, because the urgency is there, my lord, I can get it from here, I can move before, because conversion will take some time. Yes, from the court officer. That permission will be granted. Yeah.
Mr. Ral, honored advocate, appearing for
Twenty-nine in this matter, my lord, I am appealing for the petitioner. Before starting of this matter, my lord, I want to draw your lordship attention before Sita and Gita may come down from the heaven. Now, Sita and Gita, my lord, this matter, my lord, there is a contempt. We filed a contempt application. My lord, can you remember on the basis of the undertaking, we have been assured that the female person will be there. We have filed a contempt application. Violation of that undertaking. Let that be also be heard by your lordship.
Yes, that will be hard. What is the civil litigation application? Contempt is a different thing, Mr. Ral.
Why, my lord, I am submitting the assurance was given.
That I will consider. Yes. What is the order impugned?
Yes.
I have also filed.
Then this order has to be set aside. If both of you are agreed by that, best course. Both of you are not satisfied. Best course is to set aside this.
There is a trick, Millard, that page 255 of the application,
Then I will let us
Whose application? Whose application?
their application, Millard,
Yes.
this,
let us
the trial court, Millard, your lordship kindly remembers that your lordship's last order on the eve of the vacation. Millard, your lordship
Mr. Bose, both of you are agreed by this order. So let me set aside this order.
But today the child will live with the mother, and that is the trick.
Left.
Kindly see. Left. Kindly seize, Millard. The trial court, your lordship, Millard, that is the Millard, the most unfortunate part. Kindly see. No, kindly seize, Millard, your lordship. Millard, Mr. Rai is not cognizant of the fact.
World. It's the best time to relax.
Millard, kindly seize, Millard, to page 245 of your lordship. 255.
Yes, 255, yes.
Now, Millard, the date of
Mr. Bose, everyone knows your name.
আমি লিখে দিচ্ছি।
Yes.
Yes, my lord. For the petition led by Mr. Chatterjee. I can start. He's here, my lord.
The busy counsel, yes, business elsewhere. And after that matter will be passed over, then he will come, scratching his head.
No, my lord, I was engaged in other.
That is why I am saying you are busy counsel, you will be engaged in other court. Yes.
Now, my lord, plaintiff is the petitioner before my lord. In a suit for partition and declaration, my lord, seeking setting aside of a sale deed, it executed in favor of the defendant number by one of the co-sharers, my lord, on the ground fraud and other things. Now, my lord, what happened in that suit, my lord, I pray for an injunction on the ground that the defendant number one, who was initially inducted as a tenant, now, my lord, by virtue of this deed, my lord, is trying to change the nature and character by making construction over the property. Now, my lord, this was my allegation in my injunction application as in my plaint also. Now, my lord, the trial court, my lord, passed an order of status quo. Now, my lord, they contested it. In the meantime, they also filed an application for repairing, my lord, that was turned down by the learned trial court. But on its own grounds, they have never challenged it. Now, my lord, they contested the injunction application in the appeal court. Appeal court has set aside the status quo, saying, my lord,
no, initial was ad interim.
No, initial was contested.
Contested, all right.
Now, my lord, in the appeal court, my lord, if my lord sees the impugned order, my lord, the temporary injunction is set aside.
And the order of the trial judge.
Yes. Now, my lord, kindly takes up page 61.
Mr. Chatterjee, there is no requirement to file the certified copy of the trial.
Yes, my lord, I bow down. My lord, there is a requirement, and that is, my lord,
you are not
Mr.
following.
Mukherjee, my lord, I have apprised him, my lord, I have apprised him already of that. Next time onwards, he will be careful on, my lord, getting out a certified copy.
In many of his matters, this is being done.
But I know.
So, when will be the first time he will say that no next time?
My lord,
in all matters, you are saying from the next time.
My lord, I have apprised Mr. Mukherjee.
Several of his matters, this has been done. Yes, 61, yes.
Now, my lord, 63 is the ordering portion, my lord. Now, my lord, the consideration, my lord, which was said, my lord, that the defendant produces its deeds, the trial court says you cannot have a specific portion, and my lord, it was not.
Where is the finding, Mr. Chatterjee?
My lord, finding is, my lord, thus the considering the plaintiffs have a prima facie case to go for trial for demand
that is
determination of question raised in the litigation. My lord, above precedes that. My lord, on record.
Any finding? Everything before that is submission
Again,
recorded.
From again.
Show me any finding.
Again, it has
everything is submission of the parties.
Yes. Now, my lord, from here, my lord, again paragraph records some finding and then proceeds.
Which paragraph?
Just before that, thus the again it starts.
So which page?
63, my lord.
63?
Yes, my lord, I am reading this again paragraph.
Thus considering?
No, again.
Again, yes.
Again, it has been submitted by, this is consideration. Submission is previously recorded.
Yes.
Again, it has been submitted by the learned advocate for the plaintiff that the defendant number one fails to submit any deed to show his ownership of the portion purchased by him. The defendant number one previously was the tenant and subsequently he claimed that he purchased a portion of B schedule property. But the defendant number one is trying to construct building over his tenanted portion but not as on his purchased portion. Though the defendant number one raised objection against the measurement of B schedule property but never denied the existence of pahar of the pond wherein shops are running. Accordingly,
what is pahar of the pond?
Pahar means, my lord, the bank of the pond. My lord, that is nomenclatured in the Moja map as pahar. So, my lord,
pahar or par?
Par, it should be par, recorded as pahar, my lord. Accordingly, the plaintiff have prima facie case to go for trial if the defendant number one succeeds to change the nature and character of the property or is liable to grab the excess land which actually not belongs to the plaintiff will face irreparable loss and injury. Then again, my lord, this considering thus. So, my lord, it was weighed against the trial. What weighed against the trial court, my lord, is this is unpartitioned property. Defendant number one purchased. His allegation is the measurement is not correct. He is raising something or doing something on the purchase portion. My lord, if in a partition suit, my lord, nobody has a definite share in which portion. So therefore, in that judgment, my lord, one should not be allowed to change the nature and character. There are shops, let shops be there. My lord, I'm not disputing. But new construction, my lord, should not come up for which status quo was granted. Now, my lord, the appeal court.
Yes.
Now, in the appeal court, paragraph 9, my lord, is the, my lord, reasoning part of the, my lord, appeal court.
Yes.
In this context, I find from the materials produced before the learned judge that he failed to consider the schedule of the plane, specifically B schedule thereof, does not contain boundary thereof. My lord, I pose your question. My lord, in a partition suit, I mention the plot number, my lord, along with the part, along with the measurement. My lord, this is a, my lord, area where, my lord, Moja map describes a plot. Now, my lord, that is there. My lord, I cannot describe more than in a partition suit giving the respective premises number or plot number or dag number. Now, second, my lord, any finding of fact relating to construction of unauthorized building by the appellant in the stage of oath versus oath proceeding is unwarranted. So, this is absolutely erroneous in a case, my lord, where a co-sharers, my lord, fight between for partition. My lord, court will definitely protect the property instead of saying it's an oath versus oath. My lord, oath versus oath concept lies in, my lord, Order 9, Rule 13. Subject to correction, my lord. This is erroneous, my lord, consideration once again, my lord. The sale deed of the appellant bears demarcation boundary in respect of the property sold thereby was, but such boundary has not been specified in B schedule. My lord, what has been sold is the share. My lord, even if I describe a specific boundary.
B schedule is the Pukur part.
B schedule is the Pukur part.
And the defendant
A is the pond.
Defendant claims to have purchased the entire B schedule.
No. Portion from one of the co-sharer.
Portion of the B schedule.
Portion of the B schedule.
What is the portion?
My lord, if my lord takes up his defense case, my lord, page 39. My lord, facts of the case, rest are much just simpler denial, my lord. So, my lord, what he asserts in his written statement is,
yes,
the suit plot
measures the written statement in the objection to the written
a
injunction.
copy of the objection, my lord, is not handed over to me, my lord. In that, my lord, in the impugned order, there is no reflection to that. My lord, it only says he has purchased, he has a right to carry on anything on the purchase portion. So, my lord, I go by the written statement with the factual portion. My lord, he says he is running a shop, my lord, of plywood hardware, my lord, in that par portion.
Which page?
My lord, page 39.
Yes.
Fact of the case, paragraph here. I'm not troubling with the entire, but next page, my lord, page 40. And defendant number 1 on 31 August 2008, and the defendant started a business under the name and style Rahman Amin Plywood and Hardware Center, and certificate of entry was issued by such and such. Subsequently, Brojen Mondal transferred the tenanted shop and other shop room, that is 2 rooms, to the plaintiff by registered sale deed such and delivered possession there. Since then, the defendant.
Plaintiffs. You are the plaintiff.
Yes. Brojen, being one of the co-sharer, was plaintiff in the suit. So he refers to plaintiff.
2 rooms to the plaintiff.
So that is
transferred to the plaintiff. It says to the plaintiff.
No, it should be different. It should be different.
That is why I'm saying.
It should be different. So this is his case. So he's running a business. He was a tenant. There is no dispute. Our co-sharer permitted him, granted him a tenancy to run a business. He says, I'm running a business.
Passed over. Next. 63.
They ought to have served copy much earlier. Well, they have served copy to the bank at 3:40. At earlier, they ought to have served in the morning itself.
Yesterday, when you mentioned, I asked you to start.
My lord, yes.
You have not served yesterday. Now, today, from 2 p.m., when it was taken up, when I said that unless you bring him, thereafter you have
No, my lord,
served.
the fact is that he has not received my phone. From morning I am
Bank
calling
is
him.
available. Office is open. Go and serve.
My direction is that I have to serve upon you.
Moreover, let's say at the outset, civil revisional application is not maintainable.
My lord,
Because they are challenging the interlocutory order passed by the Debt Recovery Tribunal, thereby declining their
My lord,
application.
one thing, my lord.
So, DRT is the
Just a
appropriate
second.
forum.
Just a second. My lord, nothing is there. My lord, the fact
Nothing
is
is there, you are saying, so I'm.
My lord, just a second. I'm giving 1 minute time, my lord. I'm not asking for any money. My lord, the fact is that we have filed an application before the DRT that this property has not been made any survey.
Has not been made.
Survey. It has not been registered under Central Registration Act. My lord, the fact is that as per section 26D of Surfacy Act, my lord, kindly come to section 26D.
Sir, please prefer an appeal before the appellate tribunal.
My lord, one thing is that, one thing. My lord, if the learned court below has considered my application, that has already, he has not rejected my application, he has not accepted my
All right,
application.
take those points in the appellate tribunal. Yes, call the list.
My lord, 30 I am for the petition, my lord, being laid by Mr. Parthapratim Roy.
He is a busy counsel. He has gone somewhere else.
My lord, because my lord, how this matter, my lord, appeared today, my lord, we do not know because there is a can 2. We saw that a can 2 has been filed, but we have not been served. Kindly peruses the order dated, my lord, 31st of January 2025.
Oh, who paid for release? Yes, Raj Roy. Who is Yes Raj Roy?
We have
It
not
was
been
mentioned for releasing the matter because of previous order, for recalling of a previous order, an application has been filed. That is why.
for the application.
কালকে টু বি মেনশনটা দিয়ে দিন তাহলে। So I'm directing this matter to appear another hearing to be mentioned tomorrow.
My lord, better because your lordship, we need
Because
to.
they said that some previous order they have applied for.
My lord, there is an order of injunction and interim order passed. Maybe they have filed a vacating application. For that matter, it does not need to be released, my lord. Your lordship will be kindly.
But the learned advocate said that some previous order passed by a coordinate
Lord,
bench.
this is
They
the
have paid
only
for
order.
recalling.
This is the only order passed in.
So I'm keeping it tomorrow.
My lord, I will.
Mentioned appear
My
tomorrow.
lord, I will.
List is Yes, Mr. Banerjee.
And I'm
So for the opposite party.
31, Your Lordship, I am appearing on behalf of the petitioner. Before Your Lordship takes up the matter on the earlier occasion, Mr. Bhattacharya has appeared for the petitioner in this matter.
Since I'm not inclined to take up this matter on
Madam, 32, 33 and 34 I appear for the petitioners.
Yes.
Madam, this matter was made returnable on the, there was an interim order passed. Direction given to, upon the opposite party to file their opposition. And my lord, the matter was made returnable on June 23rd.
Contested application.
And liberty to mention was given.
এটা এখানে এলো কি করে?
I am appearing on behalf of the opposite party, Your Lordship.
Who is for the petitioner?
Arises from an rejection of an Order 6 Rule 17 application at the time.
One appears for the petitioner.
My lord, this is an application, my lord, whereby my.
Yes, why you paid?
Yes, ma'am. What is the limitation point, my lord? I have checked up. I have, my lord, the judgments are there. My lord, it is one.
I've forgotten. Vacation intervened.
After that shouting,
yes,
formidable opposition. Well, the application under Order 6 Rule 17 rejected. Plaintiff. I am filed suit for declaration injunction on the basis of that by way of inheritance, I got the property, they are disturbing my possession, my title has been clouded. On the basis of which I filed the suit for declaration of title permanent injunction. They filed a written statement along with counterclaim. They are claiming that yes, pursuant to a deed, they became the owner of the property. And on the basis of such deed, they filed a counterclaim for declaration of their title. So as soon as I came to know about the fact of that deed, I filed an application for amendment of my plan for incorporation of the prayer.
Yes, yes. So don't look at the back, look at the front. Yes.
That application was rejected on the ground. My amendment application was rejected that you could have taken this point in rejoinder or additional statement to the counterclaim. Now pause there for a moment. I came to know that document now they are trying to utilize against me, which is clouded my title. I am not party to that document. So I filed a declaration that deed is void or that deed is not binding upon me. Whether that to pre-trial stage.
You are not a party to that deed.
I am not party to the deed.
What is the necessity to challenge that? You are claiming title through that?
Yes, that is why. Yes, so that is why, my lord, I have to challenge.
So whether the limitation will not come
Subject to question, my lord, if my lord Kali considers 58 and 59. 3(1)(a) will not apply because per se on the date transaction is not the consideration. When the right to sue accrues, when the right to sue accrues, my lord, it came for consideration with the Honorable Appeals Court also. That soon as it came to your knowledge, not only the knowledge in the sense that what they want to do with that deed document. That is the date of the cause of action. And that cause of action came, my lord, when they filed the counterclaim. 3(1) subject to question will not apply. The declaration, my lord, if your lordship wants.
Your amendment will take into effect on and from the date of filing of your application.
Yes.
It cannot relate back to your suit.
Date of the suit. If that be so, my lord, Kali
Cannot relate back to the date of the suit.
I have to prove.
Because according to you,
the knowledge of that date.
yes. So from that you have a right to sue. So amendment with effect from it will not relate back to the date of the suit.
Yes. If that be so.
Ultimately, if you lose, you are gone.
No, my
You cannot take advantage.
My suit is 24. My suit is of 24. I have quite ever, that's why I am forgoing that portion.
Suit is of 24.
So, and 3 years is there, I have within time. So even if my lord, the now my lord takes up the order.
It was rejected.
Rejected on the ground that I have a right to take this point in my written statement or rejoinder. But pause here for a moment. I take that point in rejoinder. Today he did not press the counterclaim. Then still that document is which they are relying upon, they want to enforce against me, still it is operating on the field. And from the date when he disclosed the same, this is my knowledge. So as soon as I get that knowledge, I have a right to challenge the same. And suit for declaration, it is embodied. My lord, I need not to show that judgment for 58 and 59 Limitation Act.
We have purchased from the predecessor of theirs, from whom they are claiming their title.
Please use the microphone.
From whom they are claiming their title. We purchased in 1980. Your Lordship will find at page 41 of our counterclaim. But now, can they say that they are non-executant of the deed? Because they are claiming their title from the predecessor, from their predecessor, who was the executant of the deed, from whom we have purchased. No.
Anything more?
Pardon me?
Anything more?
But I cannot say because.
All right, Asun. This application under Article 227 of the Constitution of India
But I tender my
Previous
unqualified.
service filed in court today is taken on record.
For item number 35, my lord, I could not appear, my lord. It was.
What has been done?
My lord, it is dismissed for default, my lord. Let it appear tomorrow, my lord. Today is the date fixed in the.
It was for default.
Because not suddenly, my lord.
Nobody was there.
Tomorrow, my lord, I shall.
Somebody should have been there, just, my lord, it was required.
My lord,
But my lord,
tomorrow.
kindly, my lord, if they can.
Give the item numbers. Yes, call the next matter.
My lord, I'm-
My lord, my item number is 20.
20 and
35.
20 and 35 টা dismiss for default আছে রেস্টোর করে দিন তাহলে
মানে item
20
number
আর 35
37
তো বলছে তাহলে বলে দেবো
Okay, item number 37 I appear for the petitioner, my lords. I'm led by Mr. Aniruddha Chatterjee, my lords. He is one senior counsel, my lords.
Lord, senior or not, Lord, but the problem is it's 4:45.
It's
4:45.
Yes.
Kindly come and do it tomorrow in court.
Yes, Mr. Chatterjee. What is this matter?
My lord, I am the auction purchaser, my lord.
Who is opposing you?
No, there has to be service.
We are selling on the same board.
We will have to serve.
Who is opposing?
The bank as well as, my lord, the. May I come tomorrow to court, my lord, and do it?
If I have to see the last order, there was some.
You are opposing Mr. Chatterjee or you are also supporting?
My lord, I'll tell your lordship, the appellate court.
Party.
Yes, I am the party at my property is taken by the bank and then.
You have been served with a copy. Mr. Chatterjee, serve him a copy.
My lord. Kylie keeps it tomorrow, my lord. I'll serve it today itself.
You are appearing for?
I'm appealing for, I don't have the cost title. But a good number.
You know the name of your client.
Mr. Agarwal, kindly help him.
Yes. Respondent number 12.
125.
125.
Respondent
The
number.
borrower.
You are for the 6.
Yeah, what has been done is the appellate authority, Miller, the DRAT, has not only condoned the delay, Miller, of about a year, has also granted them leave, Miller, to put in the money of 40% of what is, Miller, what they perceive to be, Miller, the debt. And I have purchased the property, sale is complete, sale deed is in my name. And they are now challenging that sale deed, which they have already, there's an application and it's been dismissed. So for 5 years, Milord, I bought the property and I'm staring at it. I can do nothing about it.
When this matter is what is the urgency?
13th is
Milord, my entire 13th is the next date, Milord, in the appellate court. They will proceed on merits. They will proceed on merits and they cannot do that, Milord, at all. I tell your lordship why, Milord, because even the section 5 is under challenge before your lordship. The allowing section 5 saying that they have not appeared when the order is passed in their presence.
Mr. Chatterjee, it shows you do not have a very good case on merits.
I have an excellent case on merits because, Milord, they have challenged my sale.
Then, Mr. Chatterjee, why are you fighting out on section 5 only?
No, because, Milord, they are lying on oath before the court. Milord, the court has allowed section 5 on the ground that, Milord, that they had not appeared on the day, Milord, when the judgment was passed. And the appellate court allows that, Milord, section 5 allowed on the ground that they were not told when the judgment will be passed. Milord, my lord has made a matter CAV. My lord is giving judgment. They are saying they will have to be intimated when your lordship is going to give that judgment.
No, that is to Mr. Chatterjee, that is matter appears in the list.
Exactly. And it's been written in the order, Milord, that they have appeared and they have seen the order being passed. And the order is passed in their presence. The appellate court overlooks it.
Mr. Chatterjee, fight it out on merits.
Milord, I am not on, Milord, with a lot of respect, I would have fought out on merits, Milord, but now situation is that it's gone beyond my control. Milord, 1 year delay, condoned, the money waived, and what is he doing? He's challenging a sale which is complete.
So money waiver, for that I can give you liberty to approach the appellate tribunal.
No, but I am challenging it before your lordship. I am challenging it. I don't need to go back to the appellate court. I am challenging it before your lordship. I can show your lordship, my lord, the debt is about 5 crores and the appellate court is saying 90 lakhs and giving them a 40% my lord, discount.
Kindly says
Cannot
that
happen.
in order when it was filed, when it first time came before
That
lordship.
doesn't mean that you will get an that it be a walkover. No.
Now again it came after 3 months.
Mr. Chatterjee, learned senior advocate. He says 13th is the date fixed before
Yes,
the TRA.
yes, my lord.
Yes, my lord.
This matter, my lord.
2 appeals. There are 2 appeals. This appeal has been disposed of.
No, this appeal, my lord, diary number 662, my lord.
Mr. Mukherjee, instead of those controversies, whether there is any relation, how those 2 matters are related, come tomorrow.
Day after, I need to take instructions from
13th is the date, my lord. Day after is 13th. 12th.
Then it's 12.
Yes.
Day after is 12.
Fine. 12 is fine.
Then it's
You have instructions, Mr. Mukherjee.
Yes, yes.
Other instructions your clients will secure. Let it retain its position. It may not reach tomorrow. We'll go back.
I'll be very candid. In the before the Landed Debt Recovery Tribunal as well as in Appellate Tribunal, Mr. Nimish Mishra is appearing.
Nimish Mishra is appearing.
Nimish Mishra is online.
Yes, so he will not be available tomorrow.
I do not know. I need to speak
He's
to him.
online. He can tell your lordship, my lord. He's online.
Mishra is there. Yes, allow him.
He's there, my lord. He's been allowed. He is not choosing to.
Lord, I am there in the matter, but I have not been briefed in this matter. I was awaiting my call at 38. This much is a fact, my lord, that I am appearing before the learned tribunal below. I am not well aware of the circumstance.
You are posted with the basic facts.
Yes,
He's
yes,
the
that
one
I am
who's
aware of.
created
my
the
lord.
mischief.
So the matter will retain its position. If tomorrow it reaches, it will be taken up.
Before your
Very
lordship,
well.
right? There's been one mistake, your lordship.
Let,
Day after.
let the matter retain its position in the list.
Lordship, item number 35, your lordship was pleased to record my appearance and dismiss the matter for default. Lordship, that has been wrongly recorded in my diary, your lordship. My item was item number 50. I had wrongly appeared in that matter, item number 35.
Item number
For the
35.
opposite party, which your lordship dismissed for default.
This is the problem of plenty.
Yes, yes, I have restored that. 35 I have restored.
My good appearance.
35 এ যেটা opposite party শুধু ওটা restore পাস করতে